Jeffrey A. Hughes, Floyd B. McKissick Jr., William M. Brawley, Tommy Tucker, and Stephen J. Levitas. I now call for hearing in docket numbers E-2 sub 1362 and E-7 sub 1321 in the matter of Duke Energy Carolinas LLC and Duke Energy Progress LLC's joint petition for expedited review and approval of storm recovery costs. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. On December 2, 2024, Duke Energy Carolinas LLC, that I will refer to going forward as DEC, and Duke Energy Progress LLC, which I will refer to as DEP, and along with DEC, I will together refer to as Duke, filed a joint petition for expedited review and approval of storm recovery costs pursuant to Commission Rule R875D, which is the prudency review petition, portions of which are confidential. Along with the petition, Duke filed the direct testimony and exhibits of its witnesses. Also, on December 12, 2024, Duke filed a joint motion for partial limited waiver of Commission Rule R875. On December 12, 2024, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, and granting limited waiver of Commission Rule R875D21, which is the scheduling order. Among other things, the scheduling order scheduled a hearing for the purpose of receiving expert witness testimony on Duke's prudency review petition to occur, Duke's petition to occur at 10 o'clock on February 12, 2025. The public staff, which represents the using and consuming public, has been made a party to this proceeding in accordance with North Carolina General Statute Section 62-15D. In addition, the following parties petitioned to and were allowed to intervene in this proceeding: the Carolina Industrial Group for Fair Utility Rates 2 and 3, which is SIGFR, and the Carolina Utility Customers Association, which is CUCA. On January 17, 2025, the public staff filed its direct testimony and exhibits of its expert witnesses. Also on that date, SIGFR filed its direct testimony and exhibits of its expert witness. On January 29, 2025, Duke filed the rebuttal testimony of its expert witnesses. On February 7, 2025, SIGFR filed a motion to excuse its witness from appearing at today's hearing. On February 11, 2025, the Commission issued its order postponing hearing, and that order postponed the start of the evidentiary hearing until 1 o'clock on February 13, 2025, which is today at this time. On February 11, 2025, Duke and the public staff filed an agreement and stipulation of settlement. Also, on February 11, 2025, Duke filed the settlement testimony of Kendall C. Bowman and Laura A. Bateman. Also on that date, the public staff filed the joint settlement testimony of Michelle Boswell, Daryl Brown, Darius Cofield, and Finge Zhang. On February 12, 2025, the Commission granted SIGFR's motion to excuse its witness. Also on February 12, 2025, the parties filed an amended agreement and stipulation of settlement on prudency review proceeding and assumptions to be used in cost-benefit analysis and financing order proceeding, which was amended to add SIGFR and CUCA as signatories to the agreement. So that brings us to today. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good afternoon, Chair Kemmerite and Commissioners. My name is Kathleen Richard. I'm appearing on behalf of DEC and DEP. I'm joined by Jack Dirac and Kamal Robinson with the companies. I'm also joined by Kristen Athens with McGuire Woods Law Firm.
Okay. Good afternoon.
Good afternoon, Chair Kemmerite and Commissioners. My name is William Creech. I'm a staff attorney with public staff on behalf of the using and consuming public.
Okay. Good afternoon, Mr. Creech.
Also, Jennifer Herod, also staff attorney with public staff here to represent the using and consuming public. Thank you.
Good afternoon.
Good afternoon, Chair Kemmerite and members of the Commission. Christina Kress, appearing on behalf of SIGFR and CUCA.
Okay.
Thank you.
Good afternoon, Ms. Kress. And before we begin, are there any preliminary matters that need to be addressed?
Chair Camerite, the companies have two preliminary matters to bring up.
Okay, please proceed.
First, at this time, we would ask that the company's joint petition for expedited review and approval filed on December 2nd, 2024 be entered into the record and then copied into the record at the appropriate time.
Okay.
Second, Chair Camerite, we ask that the agreement and stipulation of settlement on prudency review, proceeding and assumptions to be used in the cost benefit analysis and financing order proceeding by and between the public staff, Duke Energy Carolinas and Duke Energy Progress, originally filed on February 11th, 2025, as well as the amended version filed on February 12th, 2025, adding SIGFR 2, SIGFR 3, and CUCA as stipulating parties, both be entered into the record and then copied into the record at the appropriate time.
Seeing no objection, DEC and DEP joint petition for expedited review and approval of storm recovery costs consisting of 18 pages. It was filed on December 2nd, 2024, will be admitted into the record. In addition, the agreement and stipulation of settlement on prudency review proceeding and assumptions to be used in cost benefit analysis and financing order proceeding consisting of 11 pages with 2 exhibits and supporting work papers filed on February 11, 2025 will be admitted into the record. And additionally, the amended agreement and stipulation of settlement on prudency review proceeding and assumptions to be used in cost benefit analysis and financing order proceeding consisting of 13 pages with 2 exhibits and supporting work papers filed on February 12, 2025 will be admitted into the record.
Thank you, Chair Camerite. That's all I have on behalf of the companies.
Are there any additional matters that need to be addressed before we proceed? Okay, seeing none, Duke, you may proceed.
Thank you very much. At this time, Duke Energy would call to the stand Ms. Kendall Bowman and Ms. Laura Bateman.
And before I swear the witnesses in, my fellow commissioners and I would like to make a couple of introductory remarks. First of all, we are very much appreciative and grateful for the work that Duke did after Hurricane Helene in Western North Carolina to restore service for the benefit of the customers as soon as possible. It is recognized by us the extraordinary work that Duke engaged in, and it's appreciated by the commission and by the residents of North Carolina. In addition, we also greatly appreciate the effort that we had a short time frame for this proceeding and the effort that the public staff and SIGFR and CUCA went into to audit the costs and to ensure that the costs that are going to be borne by the customers are reasonable and lowest and fully justified. So we appreciate all of the work that has gone into this proceeding. And so before we begin, and I will turn it over to my fellow commissioners if they wish to say anything as well. Commissioner McKissick?
I think the chair has done an excellent job in recognizing the extraordinary efforts that Duke went to after Hurricane Helene. I know that's very, very much appreciated, and it's always good and gratifying. We can see that there's been a consensus reached on the critical issues that are impacting the issues that are before us. So I appreciate the hard work and dedication and the give and take and compromise that led to what is before us in terms of a stipulation for our consideration today. Thank you.
Commissioner Tucker?
I just want to echo the words of Madam Chair. This was as I've heard it called, 1,000-year storm. I mean, who would have ever thought that you could be on the side of a mountain and get washed out? And the damage, according to Ms. Bowman's testimony, was $53 billion. Interstates closed, won't open until March 1st. Potential for rock slides continue. The Duke employees and those who worked in these efforts have some psychological issues with the death that was there. Just a massive storm. But again, as the chair said, extraordinary effort on Duke's part. 20,000 people, poles down, transmission lines down, on and on and on. Only access to install power for some people were by mule. I just can't reconcile it. My peer here lives in Asheville. He has seen what's going on over there weekly as he travels back home. Just incredible effort Duke made. I'm proud to be a part of knowing you guys, knowing the company, and knowing what you had done for the state of North Carolina, and most importantly, those victims that were devastated by what this storm had done to them. So long recovery still there, lots of cost, lots of repair in every area, not just with Duke, but on behalf of this native North Carolinian, thank you.
Commissioner Brawley.
Thank you, Chair. From a personal perspective, as a father of 2 children who were living in Nashville and were without power, and I made some requests, as it seemed that they were in the really bad zone, and will you tell me when they're going to get power? And on the day that I got a call from an engineer to tell me they thought it might be 3 or 4 more weeks, I was telling them the power's already been restored. And I realized you had delegated to people who knew what they were doing, boots on the ground, to make adjustments and, as the Marines would say, adjust, adapt, improvise, overcome. You restored power to the neighborhood before management even knew it, because the guys on the ground saw they could do it and they did it. Moving that fast has made a difference, and I believe saved lives in Asheville. I was there on Christmas. I was shocked at the number of people that are still living in tents, that are being fed by volunteers, that are having their laundry done or taking baths in trailers that have been brought in, knowing full well that if the building's standing, Duke Power is doing everything they can to put power into it. Thank you.
Okay. And Commissioner Levitas.
Well, I can't say it any better than what's already been said, but as the Western North Carolina representative on this commission, I want to add my personal thanks to your for your extraordinary effort. For those who haven't seen it firsthand, you just cannot imagine the extent of the devastation, and in particular, the challenges that Duke faced in trying to get us back in business as quickly as possible. It's an extraordinary effort, and I'm personally very grateful for it. So thank you.
Okay, so we will go ahead and proceed with that. And Ms. Bowman and Ms. Bateman, if you can place your right hand on the Bible, left hand on the Bible, and raise your right hand. And do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Yes. Thank you.
Thank you very much. Ms. Bowman, would you please state your name and business address for the record?
Kendall Bowman, 410 South Wilmington Street, Raleigh, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy, and I'm the president for North Carolina.
Thank you. Now, Ms. Bateman, would you please state your name and business address for the record?
My name is Laura A. Bateman, and my business address is 410 South Wilmington Street, Raleigh, North Carolina, 27601.
By whom are you employed and in what capacity?
I am employed by Duke Energy Carolinas as Vice President of Carolinas Rates and Regulatory Strategy.
Thank you. Turning back to you, Ms. Bowman, did this panel cause to be pre-filed in these dockets on January 29th, 2025, 49 pages of rebuttal testimony in question and answer form, along with one exhibit?
Yes.
And did this panel also cause to be pre-filed in these dockets on February 11th, 2025, 8 pages of settlement testimony in question and answer format?
Yes.
Do you have any changes or corrections that you need to make to either your rebuttal testimony or your settlement testimony at this time?
No, we do not.
And if I were to ask you the same questions that appear in your rebuttal and settlement testimony today, would your answers be the same?
Yes.
And did you also cause to be pre-filed a summary of the panel's rebuttal and settlement testimony?
Yes.
This time, with leave of the commission, I would ask Ms. Bowman, please read your settlement testimony summary for the commission.
Our settlement testimony, as filed, supports the original agreement and stipulation of settlement on prudency review proceeding and assumptions to be used in cost-benefit analysis in financing order proceeding filed on February 11th, 2025 by and between Duke Energy Carolinas, Duke Energy Progress, and the public staff. However, our testimony also supports the settlement as amended and filed on February 12th, 2025, adding SIG for 2, SIG for 3, and CUCA as stipulating parties. No substantive changes were made to the original settlement with the addition of these parties to the settlement. Though I note the amended settlement grants SIG for 2 and 3 and CUCA the opportunity to engage in discussions with the companies on incremental operations and maintenance storm costs, storm reserves, and storm recovery generally. The amended settlement is comprehensive, resolving all issues between the parties in this prudency review proceeding and establishing the assumptions for the quantifiable benefits analysis to be used in the related financing order proceeding pending in docket numbers E-2 sub 1370 and E-7 sub 1325. As a result of the amended settlement, the company's requested storm recovery costs have been reduced in this prudency review proceeding by approximately $262 million for DEC and $130 million for DEP, as compared to the company's original requests, which includes the company's agreement to remove the storm reserve amounts. This amended settlement was reached following the submission of testimony, substantial discovery, and extensive engagement between all parties to this proceeding. We believe this amended settlement represents a fair compromise involving substantial concessions by all parties. This is in the public interest and should be approved by the Commission. Thank you.
Thank you very much. And Chair Cameron, at this time, I would move that the policy panel's pre-filed rebuttal testimony, pre-filed settlement testimony, and the summary of their rebuttal and settlement testimony be copied in the records if given orally from their stand, and that the rebuttal exhibit be pre-marked for identification.
Seeing no objection, the rebuttal testimony of Kendall C. Bowman and Laura A. Bateman, consisting, I believe, of 49 pages, shall be copied into the record as if given orally from the stand. The one exhibit attached to the rebuttal testimony will be pre-marked for identification purposes as it has been pre-marked. The settlement testimony of Kendall C. Bowman and Laura A. Bateman, consisting of 8 pages and filed on February 11th, 2025, will be entered into the record as if given orally from the stand, and along with the summary of their settlement testimony.
Thank you. Chair Cameron, at this time, I believe there are no cross-examination questions in light of the settlement, so the panel is available for questions from the Commission.
Okay. And for confirmation, there is no cross-examination for this panel?
No.
Correct. Thank you.
Thank you.
So Ms. Bowman and Ms. Bateman, I have a couple of questions. I think that most of the questions that we have are going to be directed to witness Jiggets. If the questions that I have just a couple of them, but if the questions are more appropriate for another witness, feel free to let me know. Starting with Section 2 of the amended agreement and stipulation of settlement. And that's on page 4 of the amended stipulation. It states that with the exception, this is the second sentence of paragraph 2 or section 2, with the exception of the results of the audit of actual expenses for Hurricanes Debbie and Helene to occur in each company's next general rate case proceeding, no additional adjustments to the storm recovery costs shall apply beyond those expressly stated herein within the settlement. And can you confirm that the costs for Hurricanes Zeta and Ian, and also Winter Storm Izzy, have already been fully audited by the public staff? And that is the reason that they are not included within that statement in paragraph 2.
Yes, I can confirm that.
Thank you. And then if you can refer to section 2, paragraph 8 of the amended stipulation. And that relates to the financing order proceeding that will be handled at a later time. And section 2, paragraph 8 of the amended stipulation details the assumptions that are going to be used for the quantifiable benefits analysis, and that obviously is going to be conducted in the next phase of the securitization process. And on page 7 of your settlement testimony, you state that the assumptions that are going to be used in the quantifiable benefits analysis will guide the comparison, and I'm going to quote, between traditional storm recovery, cost recovery, and securitization to ensure a fair assessment of customer benefits. And then you have also stated that the agreed upon methodology is largely consistent with the methodology that was used in Duke's 2021 securitization transaction, and that's in docket numbers E2 sub 1243 and E-2 sub 1262, and that will provide continuity for the financing order review proceedings. So that's the background to my question. Did that make sense to give you bearing about where we're going?
Yes.
Okay. So we have reviewed the 2021 securitization transaction and order. And what we have determined is that the only really meaningful distinction that we've been able to determine from the assumptions is the timing of recovery. Is that essentially what the difference is, timing of recovery?
In terms of the agreement, the terms of the agreement here versus the terms of the agreement that were applied in the prior proceeding?
That's correct.
I think that is correct. In the prior securitization proceeding, we had reached an agreement in the rate cases that preceded that proceeding. And there were some assumptions that we agreed to make for the purposes of the quantifiable benefits test. And it was the securitization. I think the key one is the securitization would start 9 months after the base rate recovery.
Mm-hmm.
And so that's not really applicable here where we've got the storms over different periods and the securitization, we're going to use the actual securitization date. And so I think there is one provision where we said it would align with, let me get to it. So the timing. I would think the similar item for the timing is right here, E. So traditional storm cost recovery shall assume the rate case timing assumptions reflected within JIGIT's DEC and DEP Direct Exhibit 6 in the financing order proceeding. So that's kind of where we lay out the timing to assume, the timing of cost recovery to assume in that quantifiable benefits proceeding. And then the securitization would be the actual securitization time.
Okay. And so under that subsection E, just to be clear, the timing that is the rate case timing assumptions, is that the timing assumptions that were used in the 2021 securitization proceeding? Or is that a difference between, can you clarify so we can be clear on the record?
It would be a difference.
A difference, okay. And are there any, other than timing, are there any other meaningful differences between the two proceedings or the two assumptions that we're talking about? Or is it simply limited to timing?
I think that's the main one. In the rate cases, if you look at D in the current stipulation, it says shall assume a minimum 10-year amortization period for the storms. That is consistent with the DEC agreement in the last proceeding. But DEP had a minimum of 15 years. So that's a small difference.
Okay.
But other than that, I think they are similar.
Thank you. That's all the questions I have. Let me check to see if the commissioners have any additional questions. Commissioner Tucker.
Thank you again, Madam Chair. All these tabs I have, I'm not going to ask all those questions, but you know, I want to tell Duke and the public staff how much I appreciate them inundating me with paperwork, being a newbie. And I'm a normal person, so I'm not a lawyer. So it's sometimes difficult for me to ascertain what's going on. Ms. Bowman, I want to ask you about your rebuttal testimony. I don't know whether you have a copy of that
I do.
or not.
I have a
I
copy.
think it's pretty general questions. I read on page 4 where you said that the public staff, if the commission adopts based on public staff down at the bottom of the page, would have an unwarranted detrimental financial impact on the companies. And then you use the term punitive disallowance. I think your rebuttal was stern. Tell me how, had we gone down that path, and I'll revert right back to the settlement, but at this point, you did not have a settlement agreement. And what impact would that have had on investors, debt, and the company as a whole? You elaborated on it some. I just want to see what your thoughts are today.
And I believe Witness Heath can probably provide
That is fine. That's
a
fine.
more in-depth on what potential impact it could have had, but it would have, and looking at Witness Bateman, I think we would have had to have written off $140 million had we gone down that path.
Yeah. And I can jump in on the numbers. Yeah, I think we had stated $131 million of disallowance in our testimony. There's also, I think there was a table in public staff testimony that noted additional amortization may be required, so it could have been even higher than that. And it would have been very concerning for the company. And we support the settlement. We are happy with the settlement. We think the commission should approve the settlement. But that the recommendations by the public staff would have been very punitive, automatic disallowance of prudent, reasonable costs, and I would say extraordinary as well, because we've already taken an amount that's within that normal range of fluctuation. That's like 55 million that our shareholders have already borne for these storms that we didn't even ask for in our initial petition. So I think the additional amounts would have been very detrimental.
Okay, thank you for that. I guess my follow-up question is back to the settlement. And I'll wait for public staff to get up here, but I'm having a bit of concern on page 4 of the settlement agreement. Can you see where that table is?
Page 4 of the settlement agreement?
Yeah. I'm in the testimony, page 4 of the testimony, according to my lawyer friend next to me. Where the table is.
Are you in Jiggett's rebuttal? Settlement? I think, yeah, Jiggett's settlement. I can answer a question on it, but
Okay, do you see the table?
yes.
Okay, my question is, you just spoke about $55 billion worth of expenditures that you're not even asking for.
Mhm.
And then you asked for 1.4 billion. And in the settlement agreement, you accepted 1,450,000, I guess, or 45,000. How do you write off 92 million? How's that evaporate in between where you were and the settlement agreement, and why is that?
Yeah, and so let me walk down the components of the settlement agreement because not all of these are disallowances.
I realize that. I realize about the 300 million and the reserve
Mhm.
and public staff, and you agreed to kind of push that off for the time being. You don't need to belabor that. I'm just asking the 92 million,
Yeah.
that math is right in front of you.
Yeah.
What is it? I
Yeah.
mean, how can you absorb that?
And so a large portion of that is if you look at the second line, $60 million is due to estimate reductions. And so as Witness Culbreth has been refining our estimates, compared to the actuals, they are still estimates, but her estimate has come down $60 million on those storms from
So-
what we initially filed.
Okay, thank you for that. So
And it
she
will-
made a mistake by $60 million?
Not a mistake, but it is normal to have the refinement of the estimates as you get actuals in, audit invoices. And so the estimates have come down by 60 million. They are still estimates. They will be trued up in the next rate case proceeding for both utilities.
Okay, I heard this morning in the Supreme Court about regulatory lag,
Mhm.
and here we're dealing with storm recovery lag. Here, so 60 million there, so you got another 32 million
Yep.
is in the rest of these numbers down
Yep.
here that you have found that recovery costs have come in and they're lower.
No, some of these, the remaining items are for the purposes of settlement to reach an,
So these were the contested issues that you and public staff worked out, and so it reduced that.
yeah, and I would say, in the context of settlement, part of the nature of settlement is that no party's going to agree on every single item. But as a whole, as a comprehensive settlement, the parties agree that it's a reasonable and fair resolution of the issues. And so I would say kind of on all of these issues, it's not that each party agreed line by line, but in total, as a settlement, we think it's a fair outcome.
So my naive question is, you asked for 1.4, you settle for the 1.1 roughly. Is that because you rather go ahead and get the 1.1 now and agree to the settlement rather than going to court?
I think that the part of it is part of
I'm
settlement.
a novice here.
Yeah,
I'm
part of settlement is you agree to an outcome that both parties think is fair and reasonable as a comprehensive settlement, rather than go through the full litigated process.
Okay. All right. And I don't want to get out of order. I'll ask my friend on my left to help me here. That on page 9 in that same document, it talks about bi-monthly meetings between Duke and the public staff.
Yes.
What does that achieve?
Yeah, so we had recommended a change to how we calculate our incremental O&M for the purposes of, measuring storm costs in our initial petition. Public staff opposed that, and we have actually been working very closely with the public staff on trying to reach a methodology that we can both agree on. And I will say our accountants, they have been working late, working weekends, and we thought we were very, very close, but we couldn't quite get there for the settlement. So we're going to continue to meet, exchange data, dig into those details to try to reach that resolution on how to define incremental O&M. So it's very much accounting, it's very technical, but we've made a lot of progress and we're committed to continuing to try to reach that agreement prior to the next round of rate cases.
Okay. I think I heard future rate case and I heard true up. What is going to be the impact, do you think, as far as rate shock when we have to put in the rate increase to cover the storm costs?
And so
That's the general question.
Yeah.
You can't answer it. Anybody can answer it whenever.
Yeah, I'll take a stab at it. So in the next round of rate cases, the true up or the reconciliation, I really can't predict. It could be a give back of money. It could be a collection of money. So that amount we don't have an estimate of. For the securitization, I think we had in our initial phase 2 proceeding provided rate impacts of like around $2 something, between $2 and $3 for the typical residential customer. It was in the low twos. And so this settlement reduces the cost that we're going to securitize. So I would think it would proportionally reduce those rates.
Well, I asked that because we recently had a case where on water and sewer, we had to go up because the true up had not been done. They didn't increase over the years. And so we had to go up on rates 100%. And I don't want a storm recovery smoking gun here that's because we're the ones that have to, we're on the receiving end of the public hearings along with Duke. And so I'm just asking that question.
I will also add, just the nature of securitization helps reduce costs to customers. So the ability to go out and do the securitization, I think we're estimating, what do we file, about 18%, hopefully more on the day you go out to the bond market, but just the nature of this is going to reduce costs to customers as well.
Okay, I read that where it was stated. In here, I saw a 6.8 and a 6.4% interest rate. Is that what I saw?
That doesn't sound familiar.
Page 24.
Is that the settlement agreement?
I guess I'm right. Honestly, Ms. Bateman, I guess I'm right. You gave me so many books to read.
Yeah,
That's-
usually our embedded cost of debt is, after taxes between 3% and 4%. And then I know for the term loan for Debbie and Helene, we had asked for, and I do have those numbers. It was a little bit higher. We had asked for the rate after tax, it's about 4.5%. Pre-tax, it's about 5.8%.
So that's what you'll be borrowing the bond at?
Yes.
Okay, at 4.
At 4.5
Half,
after tax
okay.
and 5.8 pre-tax. And that is it's a variable interest rate loan. And so it's based on an index plus a certain amount. And so that will be updated each month, but those were the amounts as of the time of our filing.
Okay, and then either one of you can answer this. Consistently, as I was reading through this, not binding, no precedent. Nobody's binded in this agreement at all to anything. Am I correct in saying that? I mean,
So I might defer to my attorneys a little bit, but usually I think that language is about future cases, that it's not setting a precedent for how we will treat storm costs in the future, or how we will treat securitizations in the future. So it's not binding in that sense.
okay, well, I understand that from a utility law standpoint in a business situation. I mean, it seems so open-ended to me. I just don't have certainty of anything, and you guys don't have the numbers yet. So when do you think the final audit would be for Helene?
So it would be in our next round of rate cases.
Around when, I'm sorry?
In our next round of rate cases for each utility.
Okay, so that's when we would raise rates to compensate Duke for the expenditures on Helene in the next rate case?
No, that would happen. So the securitization proceeding that we're in.
Separate.
Yes,
Okay.
and so we're seeking to securitize the estimates updated for the settlement. And we are aiming for, I think it was October, November of this year to close on the securitization bonds. And we appreciate the commission kind of expediting the process to allow us to do that. So we would issue those bonds and then it would be reflected in customer rates at that time. So the
Okay.
November, I think, is what we've projected, November of this year.
Thank you,
And
ma'am.
that's the $2+ and it will come down as a result of this settlement. And we will file that update in the phase 2 proceeding likely next week.
So for my element of certainty, you can say, you'll definitely say it's no more than $2.
No,
I didn't think.
I would not say that. So
Yeah.
we are working on the calculations, hope to file them next week.
Yeah, Madam Chair, no further questions.
Thank you. I've got a couple of follow-up questions for Commissioner Tucker, and then I believe that Commissioner Levitas has a question and perhaps some others do as well. Following up on Commissioner Tucker's question, I'll direct this to you, Ms. Bowman. This is related to your rebuttal testimony when you referred to or characterized some of the adjustments that the public staff made to the cost as being punitive, and you objected to some of the adjustments. Duke has entered into a full and comprehensive settlement of all issues with the public staff and with SIGFR and CUCA. Is that correct?
That is correct, as it relates to this proceeding.
As relates to this proceeding, and you are asking that the commission approve the stipulation and settlement. Is that correct?
Yes, we believe it's in the public interest.
And is it your position, you've entered into the settlement, so presumably Duke believes that this is fair and reasonable to both Duke and to the customers. Can you confirm that or add anything to it so that we can be clear for the record?
Yes, we absolutely believe this is a fair and reasonable settlement, and we are supportive of it.
Fair and reasonable settlement for both Duke and customers. Is that correct?
Yes, ma'am.
Okay. And Ms. Bateman, just to be clear for the record as well, when you answer questions about the estimated costs in response to Commissioner Tucker's questions, those estimated costs are estimates. However, they will be fully audited in the next rate case proceeding. Is that correct?
That is correct.
Okay, thank you. I just want to make sure the record was clear. Commissioner McKissick.
And this is just a question for purposes of clarification. I know you contemplate selling the bonds in October, early November of 25. But are there factors that could substantially impact that timing and scheduling that would either allow you to sell them earlier or that will result in a delay?
So I'm going to answer yes, and I think Witness Heath would be the one that could provide more details on what those circumstances would be.
Very good. I thought he likely would be as well, but I thought I would pose it to you at this time. Thank you.
Commissioner Levitas.
Thank you. I just have two very quick questions. I may have missed it, but I did not see in the settlement testimony any kind of explanation for the additional $1 million of reduction in carrying costs. I believe there was a dispute between the companies and the public staff regarding the appropriate methodology to be used in calculating the interest rate. And so does that, and if I recall, the delta was approaching 2 million. So was that just sort of splitting the difference in the interest of settlement? And am I right in thinking that there's, to Commissioner Tucker's point, no precedential position or determination with respect to what the appropriate methodology should be going forward?
I would agree with that. There's no presidential precedent setting to it, and that the parties, still disagree on the methodology, and the $1 million is for the purpose of settlement.
Okay, thank you. And this may be just sort of off the wall or a crazy idea, but I know you're going to be working with the public staff going forward on the possibility of storm reserves. And there's a lot of discussion in the testimony about the cost of creating a reserve and then the relationship of that cost to the potential earnings on the reserves once, if and when they were put in place. Is it worth considering in those future conversations whether earnings on reserves should be used to defray the cost of creating the reserve rather than increasing the principal of the reserve that's available for storm recovery?
I think we're pretty broad and open to what's included in that discussion.
Good. Thank you very much. That's all I have.
Commissioner Brawley.
Thank you, Chair. This actually occurs in 4 different places, but I'm going to use the stipulation, page 4. There's a number 2 with some things below. In C, there is a reduction in carrying costs to reflect the application of a debt-only return on Hurricane Zeta, Hurricane Ian, Winter Storm Izzy recovery cost instead of the weighted average cost of capital authorized under NC General Statute 62-172. So the company is given a lower rate on that, interest only, rather than what the law allows, weighted average cost of capital. Is that difference going to be, are you going to seek to recover that difference in the next rate case?
No.
Is there a reason why y'all ended up with a lesser rate of return than what the law calls for?
So I would again point back to settlement, comprehensive settlement. So neither party agrees with each line item of the settlement, but as a whole, as a comprehensive outcome, both parties think it is fair and reasonable.
So some of the parties believed that Duke receiving the legal rate of return on this was not fair and reasonable?
Correct.
All right. Thank you.
Thank you. That comes to the end of commission questions. So I'll turn to questions on commission questions. Okay.
Just very briefly, thank you, Chair Cameron. You were asking questions from Commissioner Tucker about the intersection between securitization and the future rate case. So I want to just make sure record's clear on that point. And Commissioner Tucker was raising concerns about potential future rate increases coming through the rate case. So just to be clear, the pathway of cost recovery using securitization is a distinct pathway from recovery through base rates, correct?
That is correct.
And assuming the commission approves and we're successful in the securitization transaction, the vast majority of the cost recovery for these storm costs will flow through the securitization process, correct?
That is correct.
And the company's best estimate, you stated, of the cost impact for customers, correct?
Correct.
And the true up that will occur in the rate case, can you just briefly describe what that, at a very high level, what that entails?
Yeah, and so what we are including for the settlement are our best estimates as of this point in time with the adjustments in the settlement. As we move forward, we will continue to refine those estimates. And then in addition, as Chair Camerite said, the public staff will audit those estimates when they'll audit the actuals, when the actuals are final. They will audit that in the next rate case, and any findings of their audit would be part of that rate case, as well as true up to the actuals. And so we don't know at this point whether our estimates are too high or too low, or spot on. I mean, the true up could be 0. But these are our best estimates as of this time. I don't think it will be significant compared to the amount that we're securitizing.
So our best understanding at this time is that there'll be adjustments around the margin subject to public staff's audit, but the vast majority of the cost impact of these storms is going to be the storm recovery charges that ultimately flow from securitization.
That is correct.
Okay. One quick question for Ms. Bowman, you, before we close here. You heard some comments at the start of this proceeding about the appreciation for the hard work that went in the settlement. Can you speak just a little bit about the hard work and concessions that were required to get to the settlement that's now in front of the commission?
Yes. So I will say all of the parties involved spent, I think witness Bateman already said, lots of time and hours on this. It is important for us to expedite the storm recovery costs. It is a large amount. The company is bearing that cost. We had to start spending dollars on day one when this happened, and it is important for us to expedite this, and it is important to be able to reach this type of a settlement and compromise, working with the public staff and SIGFR and CUCA. So it's a complex proceeding. Securitization is complex. There's a lot of moving parts, as you can tell by all of the documents that you've had to read. And so us being able to achieve this compromise is extremely important and is definitely in the best interest of the citizens of North Carolina, as well as the company.
Thank you. No further questions.
And Ms. Bowman, I do have one follow-up question in regard to your last answer. You talked about concessions that had been made to reach the settlement that you are asking that the commission approve. And I'll ask the same question of the public staff, but is it your understanding that the public staff and SIGFR and CUCA also made concessions in order to reach this comprehensive settlement, so that it was this comprehensive settlement that everyone could support?
Yes, there was give and take by all parties.
Okay, thank you. Are there any questions on my last commission question? Okay, Mr. Durack, any follow-up question on my commission question?
No questions.
Okay, thank you very much. We appreciate your testimony, and you may be excused.
And I believe, Chair Cameron, I need to move the policy panel's rebuttal testimony, the summary, one rebuttal exhibit, and their settlement testimony into the evidence.
Okay. Seeing no objection, your motion is allowed.
Thank you.
Right. Duke Energy calls witnesses Brent Guyton, Melissa Culbreth, and LaWanda Jiggets as a panel to the stand.
Good afternoon. I'll go ahead and get you sworn in. If you can place your left hand on the Bibles and raise your right hand. And do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Mr. Guyton, would you please state your name and business address for the record?
Brent C. Guyton, business address is 555A Brevard Road, Asheville, North Carolina.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolina as Director, Asset Management Distribution and Power Grid Operations.
And did you cause to be pre-filed in these dockets on December 2nd, 2024, 35 pages of direct testimony in question and answer form as corrected by an errata filing?
I did.
Did you also cause to be pre-filed in these dockets on January 29th, 2025, 7 pages of rebuttal testimony in question and answer form?
Yes, I did.
And do you have any changes or corrections to your direct rebuttal testimony?
No, I do not.
And if I were to ask you the same questions that appear in your direct rebuttal testimony today, would your answers be the same?
They would.
Did you prepare and file a summary of your direct and rebuttal testimonies?
I did.
Chair Cameray, at this time, I move that the pre-filed direct and rebuttal testimony of Mr. Guyton and his direct and rebuttal testimony summaries be copied into the record as if given orally from the stand.
Seeing no objection, the direct testimony consisting of 35 pages, it was filed on December 2nd, 2024, and it was corrected via errata filing on February 11th, 2025, shall be copied into the record as if given orally from the stand. The rebuttal testimony consisting of 7 pages, filed on January 29, 2025, shall be copied into the record as if given orally from the stand, along with the summary of his testimonies.
Thank you, Chair Cameray. Ms. Colbreth, would you please state your name and business address for the record?
My name is Melissa Colbreth. My business address is 410 South Wilmington Street, Raleigh, North Carolina.
All right. And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as a Director of Financial Planning and Analysis.
And did you cause to be pre-filed in these dockets on December 2nd, 2024, 24 pages of direct testimony in question and answer form and 4 exhibits?
Yes, I did.
And did you cause to be pre-filed in these dockets on January 29th, 2025, 19 pages of rebuttal testimony in question and answer form?
Yes.
Do you have any changes or corrections to your direct or rebuttal testimony or exhibits?
No, I do not.
If I were to ask you these questions or these same questions that appear in your direct or rebuttal testimony today, would your answers be the same?
Yes, they would.
And did you also prepare and file a summary of your direct and rebuttal testimony?
Yes.
All right. Chair Cameray, at this time, I ask to move the pre-filed direct and rebuttal testimony of Ms. Colbreth and her direct and rebuttal testimony summaries be copied into the record as if given orally from the stand, and her direct exhibits be pre-marked for identification.
Okay. Seeing no objection, the direct testimony of witness Colbreth consisting of 24 pages filed on December 2nd, 2024 will be copied into the record as if given orally from the stand, along with her rebuttal testimony consisting of 19 pages filed on January 29, 2025. In addition, the summaries of her testimony will be copied into the record as if given orally from the stand. The 4 exhibits attached to the direct testimony will be marked for identification purposes as pre-marked.
All right. Thank you, Chair. Ms. Jiggets, would you please state your name and business address for the record?
Yes, I'm LaWanda M. Jiggets. I work at 410 South Wilmington Street, Raleigh, North Carolina, 27601.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as a Director of Rates and Regulatory Strategy.
And did you cause to be pre-filed in these dockets on December 2nd, 2024, 25 pages of direct testimony in question and answer form and 4 exhibits, including the supporting work papers?
Yes, I did.
And did you cause to be pre-filed in these dockets on January 29th, 2025, 39 pages of rebuttal testimony in question and answer form and 3 exhibits?
Yes.
And do you have any changes or corrections to your direct or rebuttal testimony or exhibits?
No, I do not.
And if I were to ask you the same questions that appear in your direct or rebuttal testimony today, would your answers be the same?
Yes, they would.
All right. Did you also prepare and file a summary of your direct and rebuttal testimonies?
Yes, I did.
Chair Cameray, at this time, I ask to move that the pre-filed direct and rebuttal testimonies of Ms. Jiggets and her direct and rebuttal testimony summary be copied into the record as if given orally from the stand, and her direct and rebuttal exhibits be pre-marked for identification.
Okay. Seeing no objection, the direct testimony of witness Jiggets consisting of 25 pages filed on December 2nd, 2024 shall be copied into the record as if given orally from the stand. Also, her rebuttal testimony consisting of 39 pages filed on January 29, 2025 shall be copied into the record as if given orally from the stand. Also, the summaries of her direct and rebuttal testimony will be copied into the record as if given orally from the stand. The 4 exhibits attached to her direct testimony will be marked for identification purposes as pre-marked, and the 3 exhibits attached to her rebuttal testimony will be marked for identification purposes as pre-marked.
Right. Thank you, Chair Cameray. Ms. Jiggets, on behalf of this panel, did you all jointly cause to be pre-filed in these dockets on February 11th, 2025, 11 pages of settlement testimony in question and answer form, including 4 settlement exhibits?
Yes, we did.
And do you have any changes or corrections to your settlement testimony or exhibits?
No, we do not.
And if I were to ask you all the same questions that appear in your joint settlement testimony today, would your answers be the same?
Yes, they would.
Did you also prepare and file a summary of your joint settlement testimony?
Yes, we did.
Ms. Jiggets, will you please read the panel's joint settlement testimony summary for the commission?
I'd be happy to. Our settlement testimony supports certain components of the agreement and stipulation of settlement filed on February 11th, 2025 by and between Duke Energy Carolinas, Duke Energy Progress, and the public staff. Although our testimony as filed specifically supports the initial settlement, it is also applicable to the amended settlement filed on February 12th, 2025, adding SIGFR 2, SIGFR 3, and CUCA as stipulating parties, and we support the settlement as amended. I specifically support the company's updated total storm recovery costs and sponsor settlement exhibits 1 and 2, which provide the updated incremental operation and maintenance, O&M expenses, capital costs, and accrued carrying costs incurred as a result of Hurricanes Helene, Debbie, Zeta, Ian, and Winter Storm Izzy through October of 2025 for DEC and DEP respectively, compared to what was originally filed on December 2nd, 2024. Ms. Colbreth and Mr. Guyton support the adjustment to the company's incremental O&M costs, capital costs, and other financial components. Ms. Colbreth also sponsors Colbreth Settlement Exhibits 1 through 4. Colbreth Settlement Exhibits 1 and 2 support the total incremental O&M costs for Zeta, Izzy, and Ian for DEC and Ian for DEP, and provide the cost by function and cost category for each storm. Colbreth Settlement Exhibits 3 and 4 support the company's updated total estimated incremental O&M and capital costs for Hurricanes Debbie and Helene, and detail the estimating categories by function for each storm. In summary, we believe the settlement represents a just and reasonable resolution of all issues in this proceeding, reflects a constructive approach to providing necessary recovery for prudently incurred incremental and extraordinary storm recovery costs, which will allow the companies to maintain their financial stability while also delivering quantifiable benefits to customers through securitization.
All right. Thank you, Ms. Jiggets. Chair Cameron, it's also my understanding that the parties to this proceeding have waived cross in light of the settlement. So with that, the panel is available for commissioner questions.
Okay. And Ms. Richardson, I may have missed it, but have you asked that the joint settlement testimony and the summaries be copied into the record?
I have not, Chair Mitchell, or I'm sorry, apologies, Chair Kemmerite. Chair Kemmerite, at this time, I would ask that the pre-filed settlement testimony and summaries be moved or copied into the record as if given orally from the stand, and their and their settlement and summary exhibits be pre-marked for identification.
Okay. Thank you. Saying no objection, their joint settlement testimony consisting of 11 pages filed on February the 11th, 2025 will be copied into the record as if given orally from the stand. The exhibits and work papers that are attached to the joint settlement testimony will be marked for identification purposes as pre-marked, and the summary of the joint settlement testimony will be copied into the record as if given orally from the stand.
Thank you, Chair.
Okay, thank you. And Ms. Richardson, I believe you said that there is no cross-examination that you're aware of for the panel?
That is my understanding.
Okay. So I will proceed with questions for the panel. Most of the questions we have are directed to this panel, but I wanted to go back to some of the questions that we asked of the previous panel. And there were some questions about the give and take in reaching the stipulation and settlement. And so I'd like to hear some information from the panel about, you have asked that the commission approve the settlement agreement. Is it your position? Can you provide your position about whether this is fair and reasonable to all of the parties, Duke and the public staff and the customers, and in the public interest?
I do think that it's a fair and reasonable compromise for the company and the customers to recover our reasonably and prudent storm costs associated with all the storms included in this proceeding. As we've kind of discussed and you've heard, like Helene and Debbie were major storms that impacted our storm territory, and the company went above and beyond, I believe, to try and get all of our customers back with their power restored as quickly as possible. And the settlement that we reached in this agreement will allow us to recover those costs in a timely manner, moving forward with the securitization benefits our customers because it's at a lower cost of recovery compared to traditional rate making. So I do believe that the outcome of the settlement benefits our customers overall.
And the same question that I had asked at the previous panel, we talked a little bit about some give and take to enter into, to reach the settlement among the parties. And some of the questions were about, I think for Ms. Bowman, about the give and take that Duke had entered into and some concessions that Duke had made to be able to enter into the settlement. Is it your understanding that the public staff and the other parties, SIGFR and CUCA, also made some concessions in order to reach the settlement and enter into the settlement?
That is my understanding as well.
Okay. So my next questions are going to be somewhat technical. So I'm going to refer to, I believe, Ms. Jiggets, this is for you. You might want to turn to Settlement Exhibit 1.
I'm there.
So it's the first work paper supporting Settlement Exhibit 1, and it is the first page after Settlement Exhibit 1.
Okay. Just so that we're clear, is it at the top of the page, the cumulative storm recovery costs balanced by storm?
That is correct.
Okay, yes, ma'am.
And this work paper shows costs for Zeta, Izzy, Ian, Debbie, and Helene. Is that correct?
Correct.
Okay. Beginning on line 26 through line 40, those are dates after the occurrence of Hurricane Helene. Is that correct? Line 26 begins with October 31st of 2024.
Yes.
And so what we're interested in is the information for Hurricane Helene. And under line 26, it is 241,921 is the cost at that point. Is that correct?
Correct.
Okay. And then on line 40, which ends with December 31st, 2025, we have the 504,251 figure. Is that correct?
251. Can you say that one more time?
504,251. Is that correct?
Yes.
Okay. And so the way that we are interpreting this column is that the costs are continuing to grow from October 31st of 2024 until December 31st of 2025. And can you explain why the costs continue to grow, especially 1 year after the storm's occurrence? So for example, from line number 38 of December 31st of 2025 until December 31st of 2025, why are the costs expected to continue to grow?
Yes, and so what you're seeing reflected here is that when the storm initially hit in September, we had some of those costs come in through September, but the storm also went into the next month of October. That's why you see the initial big shift there for the initial what we call restoration, O&M, and capital spend associated with that storm. What we are also including in this proceeding, and Witness Colbert can add some additional information about this, is additional costs for what we call the rebuild phase, which is where we'll have additional O&M and capital expenditures beyond the normal initial restoration date. And that is projected to continue through 2025. So that's what you see causing slight shifts in the balance throughout the additional time beyond the initial restoration date. I believe for our purposes, we've reflected those incremental expenditures that are going to happen through the next year on a quarterly basis. But Ms. Colbert could provide more context as to what's driving that.
Can you provide what those costs generally are so we can better understand those costs?
So I will touch on that and then I will hand it to Witness
Okay.
to provide further detail. But we did restore service to the best of our ability, but there was a lot of infrastructure that needs to be rebuilt. You know, we did enough to get the lights on, restore service to our customers, but there is other damages that we need to spend a little more time on and be more thoughtful about. So I will turn that to Witness Guyton.
Yeah, so, excuse me. So what all start with is we have system, and I talk about this in my direct testimony. After we've restored customers, we have a return to system normal phase of the restoration. A lot of times it's switching circuits back to their normal configuration, doing some other cleanup work that did not cause an outage. From that perspective, maybe a pole is cracked but wasn't broken. We need to replace that pole, but it's not causing an outage for a customer. What's unique about Helene is the amount of work that needs to be done after lights are on. I believe it's on page 26 of my direct testimony. There's a picture of some of our poles that are in the river where the road was washed away, where those were standing. We couldn't rebuild that line during restoration back where it was supposed to be. We had to put that line on the other side of the road based with cooperation with DOT. We will eventually have to put that line back or in the appropriate place that we're permitted to be, but in essence of restoration. And there's a lot of that work that we've done. The issue with the work continuing longer than normal, there's actually some roads there in the area that public staff came up and toured with us that we don't know when DOT is going to rebuild that road or when we will be able to make those connections back through there. Now, we've restored all devices that are part of the storm. We don't know the customer count that's not there, but all devices and areas that can receive power or residences or businesses have power from that perspective, but some of them don't exist anymore from that perspective. We've got normal processes for application for service to deal with that. But does that make sense about the extended rebuild type of effort?
It does. And I see on this schedule that there are no costs after the end of 2025. Is Duke anticipating that all of the work will be completed and there'll be no additional costs after December 31st of 2025? Is that why the costs end at that point?
To the best of our knowledge, yes. But again, there may be some areas if DOT doesn't rebuild, but we'll look for ways to reconnect circuits, et cetera, that may not be connected right now. But that is very limited in scope in the hardest hit areas of the mountain zone where I live.
Okay. And so following up on, you said the public staff accompanied Duke in some to witness and to see what was happening in Western North Carolina. Was that part of this proceeding, or was it part of their general investigation, or both?
That would be a question for them of the specificity of what they were determining. But I will say that as we work very closely, and there's a section that I particularly represent of MYRP overlap. You all may have questions about that, and I can explain that. But that was a lot of intense discussions with public staff. And we were able to, some of the things that they saw when they came up for that tour, we were able to reference in explaining some of the concepts as we were looking through that to determine that overlap. But we worked very closely with them. I don't know if the actual securitization was a determining factor, but I'm trying to remember the timing. I think they may have been up there as the securitization was filed. So I think they had planned that trip to just determine and lay eyes on, what happened during restoration. But that would be a question for public staff.
I'll ask the public staff this, but in other words, the public staff's investigation went beyond just looking at paper filings. They were part of a physical investigation.
They spent 3 days up there with Brian Newmick, who was here with me, and Jason Hollifield for that briefing in December. They were all engaged with public staff when they were there visiting.
Okay, thank you. So we talked a little bit with the last panel about carrying costs, I believe. And let's turn to Section 2, Paragraph 3 of the amended stipulation. And that paragraph states that the stipulation does not constitute endorsement or acceptance of either the company's or the public staff's position on whether the weighted average cost of capital should be compounded monthly or annually, and the parties reserve the right to argue their prospective positions in future proceedings. And then in paragraph 2C, carrying costs are also addressed in the amended stipulation. There was a reduction of carrying costs, and then there was also a reduction of an additional $100 million of carrying costs. So with those two different paragraphs addressing adjustments for carrying costs, is the calculation that was used in Section 2, paragraph subsection C, Did that rely upon monthly or annual compounding, or was that addressed at all in that section?
So under the terms of the stipulation and how the calculations are working is we are using a 100% debt-only return. It is at the monthly compounding as in the company's initial filing. So debt-only with monthly compounding is what's reflected in the calculations today.
Okay, thank you for that clarification. I believe it was either Commissioner Tucker or Levitas who asked about under subsection C about the additional $1 million reduction in carrying costs. And the answer that I heard from the previous panel was that was how they came about the $100 million reduction or adjustment was part of the settlement of give and take. But is there any more specificity that you can provide about how that $100 million reduction was arrived at?
I can't provide any more additional beyond that. It was just an agreed upon number between the parties and the spirit of compromise to reach a settlement. It was split $500,000 between both companies is how it's reflected in the numbers before you today.
Okay. And Duke believes that that is a fair compromise for that issue because you've entered into the settlement. Is that correct?
Yes, we do.
And then in section 2, paragraph 2B, there is a reduction of about $60 million to Hurricanes Debbie and Helene estimated costs. Can you provide some more information about how you and the public staff arrived at the reduction of the $60 million for those two storms?
Yes, I believe that the split is about $38 million for DEC and $22 million for DEP, and Witness Colbert can tell you how that number was derived based on our processes.
Yes, so we start soon after the storm with a fairly good estimate based on the inputs and the information that we know at that time, based on the number of resources we had on site, staging and logistics costs needed to accommodate those resources, estimates of materials and such. So that estimate is available probably 7 to 10 days after the storm restoration activities are complete. But as time passes, that estimate improves. So we have better information on materials issued, materials returned. We have better information of the actual resource counts, their length of stay and such. So at this point in time, a lot of our internal costs for our internal resources have been recorded, and we felt very confident in reducing the estimate by $60 million at this time. So this is the best information we know today.
Okay. And just for clarification, the reduction of $60 million was due to an improvement of the estimate. It was not due to give and take for reaching a settlement. Is my understanding correct?
It is an improvement of the estimate, but was also agreed to in the settlement agreement.
Okay, thank you. So let's turn to section 2, paragraph 2D now, and this relates to the store's loading costs. And that section removes about $530,000 of Duke's store's loading costs from storm recovery costs. And I had reviewed public staff's testimony that I don't think you need to look at. It's on page 8 of the public staff's testimony. And the public staff had recommended removal of about $833,000 from DEC and about $60,000 from DEP because the public staff's position was that those costs were not incremental storm costs. Can you explain how you arrived at the $530,000 adjustment? Because that is less than the amount recommended by the public staff. How was that arrived at?
Through discussions with the public staff and analysis of both our position and theirs, there was an agreement to the $530,000 reduction of those stores loader costs.
Was that give and take where the public staff agreed to a lesser adjustment than they had been recommending? Is that how it was arrived at?
There was some give and take to come to that agreement of that amount.
Okay, so I assume that was a concession of the public staff.
Assume.
Okay. And then in section 2, paragraph 2.4, Duke and the public staff, that section discusses the bi-monthly meetings that Duke and the public staff are going to be having. And what those monthly meetings or bi-monthly meetings are referenced is to reach the methodology for calculating the incremental O&M costs. In addition to O&M costs, are Duke and the public staff also going to be discussing trying to agree to a methodology for treatment of store costs and that have been addressed in the amended stipulation? Or is it simply related to the incremental O&M costs?
Could you repeat your question? Are you referring to the store's loader cost?
Yes, excuse
That
me,
part of
yes.
it too. The stipulation states that we will be discussing the incremental O&M methodology. Storage loader costs will be a part of that. It's very detailed to get through that analysis.
Mhm.
And so all of our O&M costs will come into play as we work through that methodology.
Okay. And one of the main issues between Duke and the public staff before you entered into the stipulation, and you're going to be trying to resolve this through the bi-monthly meetings, was how to determine the incremental O&M costs for storms. And in the stipulation, it states that that Duke and the public staff will meet to try to reach agreement on the methodology for calculating the incremental O&M costs for hurricanes Helene and Debbie and all 2024 storms not included in the securitization filing. My understanding about that is coming from the language of the stipulation. So if Duke and the public staff are able to enter into an agreement about the methodology, well, that methodology, is it anticipated that that methodology will be used for all storms going forward? Or explain how will that agreement be implemented if you're able to reach an agreement with the public staff? What is the practical effect of it?
So the intent is to get consensus on the O&M methodology that we will use going forward from 2024.
Okay, for all storms.
For all storms.
Okay. And I'd like to have clarification for the record about amortization. And does the amortization for all storms in this proceeding begin once the bonds are securitized?
So with respect to, just for clarification to make sure I understand your question, are you asking when will we begin recovery of the bonds, assuming they are issued?
That is correct.
Yes, so recovery of the bonds, once we are successful in having the bonds issued and the charge established for the customer payments, we will begin reflecting the applicable accounting adjustments at that time to show cash coming in and payments going out associated with the bonds.
Okay, and what is the time frame? How quickly does that occur?
So I am not 100% sure of the exact time frame. I believe the exact method for accounting and how that works is in Witness Sparrow's testimony in phase 2 proceeding. He kind of lays out the accounting that happens. But I do believe that, again, like once the bonds are issued, the charges would start to reflect on customers' bills in the next month.
In the next month. Okay, thank you. And then there was some dispute about the external auditor, and that was addressed in the stipulation as well. And just for background information, how frequently does Duke use an external auditor in the past for storms? How frequently has that occurred?
For the storms in this proceeding, we used an external auditor for the Hurricane Ian storms. How often we do that depends on several factors. Depends on the impact to all of our Duke service territories. In the case of Ian, we had impact in Florida and in the Carolinas. Depends on the number of resources that are needed to restore power. So the more resources, the more invoices we have to process. And therefore, as well, the staging and logistics costs. So it depends on the nature of the storms, the impact of the storms, and the normal workload and staffing that we have.
So going back going back more historically, after Ian, how frequently can you help the commission understand how frequently Duke uses external auditors for storms? Is this something that occurs regularly or very rarely, or can you give us an idea of how frequently this happens?
To my knowledge, we have not used an external auditor since Ian. With the impact of Debbie, Helene, and Milton, which impacted Florida mainly. I do know that our invoice processing team was considering using one at this time, but I do not know if they have at this point.
And do you have any idea about going forward, whether you anticipate that the external auditor is going to be used frequently or sparingly? We're trying to understand, is this really a real issue that we need to be paying a lot of attention to?
I do not have a feel going forward. Again, it depends on the impact that our service territory sees.
Okay.
We are staffed at a position now to handle somewhat of a normal workload, but extraordinary events such as we've seen in 2024 could warrant the use of those and of an auditor. But
okay. And so far for Hurricane Helene, you have not needed to use an external auditor. Is that correct?
that is correct.
Okay. Are you anticipating that you might need to, or do you think that you have the resources to proceed with Hurricane Helene without the use of external contractor?
At this time, I'm not aware that we've engaged with an external auditor for Hurricane Helene.
Okay. And then Ms. Jiggets, I think we've got just a couple more questions for you. In section 2, paragraph 2F of the amended stipulation, the stipulating parties agree to an adjustment revising the maximum amount of storm costs in the normal range of fluctuation. In other words, the remaining amount at risk for calendar year 2020, as recommended by the public staff and reflected in Jiggets Rebuttal Exhibit 1. And then beginning on page 8, line 12, and then also you discuss this on page 9 of your rebuttal testimony, you discuss the adjustment. And on page 9, lines 9 through 12, you state that DEC's agreement with the public staff's rationale for the adjustment is an adjustment of $106,269. Is this the amount of the agreed upon adjustment?
Yes, it is.
And then can you tell us on what specific line item and column on your rebuttal exhibit 1 is that adjustment reflected?
One moment, Commissioner. Excuse me, Chair. So I'm going to take you to two pages in the exhibits and then the supporting work papers to kind of help you see it. So if you're on Jigget's Rebuttal Exhibit 1, and if you look at incremental costs on line 17 for Zeta, you'll see a reduction of about $60,000. That $60,000 includes the 106.
Excuse me, what page are you on?
I'm on, for Jigget's Rebuttal Exhibit 1, page 1 of 1. And we're looking at line 17. So again, the 106 is included in the 60 that you see there. And if you give me one moment, you can see the split out of that 60 between the 106 and the 40. 46. If you go to the very last supporting work paper for Jigget's Rebuttal Exhibit 1, it'll say North Carolina incremental storm cost data. And what you will see is on that page, I show adjustments on line 3 of $46,000, and then adjustments on line 4 for the 106, that's a reduction.
Thank you. That's all the questions I have. I appreciate the detailed information. Let me see if there's any additional questions. Commissioner Tucker.
Thank you, Madam Chair. Earlier, Councilor Direct talked about bonding and storm recovery costs being separate in the way that here for that.
Yes.
Under, I believe your testimony as referred to earlier on page 5, 2E. This is in settlement that starts with a reduction.
Are you looking at the settlement itself, Commissioner?
Yes, ma'am.
Okay.
Yes, ma'am.
Okay.
Got it?
Yes, I do.
Yes, ma'am. Tell me what that means.
A reduction to remove the estimated multi-year rate plan.
Correct.
So I'll start a little bit and then I'll ask, witness Titan to provide additional context, but basically through the course of the public staff's review, they identified some projects or some costs that were capital in nature that were included in the initial estimates for Helene that we determined were also going to be a part of our multi-year rate plan that was already included in customers' rates. And so witness Titan can provide additional context for that.
Excuse me. Yeah, this is another really good example of the extreme coordination between public staff and our technical folks in my team, as well as our project management team. So three of you weren't here when I was here before representing our multi-year rate plan projects, but let me tell you what those are. They're typically the most common distribution project that I represented in the last rate cases was what we called substation and line projects. So we may have the Smith substation. It has 3 or 4 circuits out of it. It's in some part of our service territory. And we've identified some pretty extensive work to do to improve the service for those customers.
Let me interrupt you for a second. Can you speak into the microphone? Those in the back of the room are having trouble hearing you.
I'm sorry, I'll start over. So when I represented our multi-year rate plan projects in previous proceedings, one of the key projects or types of projects for distribution was substation and line projects. And those typically were centered around a substation. For instance, Smith substation, there may be several circuits out of that substation, and we've identified grid improvement work to do on those circuits for the benefit of customers. Examples will be some things such as self-optimizing grid, which is our automated system that detects power outages and switches automatically with no human intervention. There may be other grid hardening efforts, infrastructure integrity, and things of that nature. Within quite a bit of those different types of work that I described for those projects, a simple example would be pole replacements. We may have some work we're doing on Smith Lane. There are 12 poles on Smith Lane, and we've identified as part of that project that 3 very specific poles, not any 3, but there are 3 specific poles in those 12 that need to be replaced when we're doing that work on Smith substation. Because it's an MYRP project that was included in the commission's order, that either already is in customer rates or will be in customer rates going forward. And as we gathered our costs for Helene, but 3 of those 3 poles may have been replaced by a crew doing restoration. They may have been broken by Helene. A crew doing restoration replaced those poles to get the lights back on Smith Lane. No idea that we had a multi-year rate plan project that was already in rates. We're getting the lights back on. So working with public staff, we determined a methodology to actually find those locations where we had work that we had not completed yet by the time Helene came, and verify did the restoration efforts actually finish or complete some of the work that would have been done because it's already or will be in customer rates. That $8.4 million that we identified was brought out of our securitization because it is already in or will be part of a commission or is part of an order for rates for customers from that perspective. The way we calculated that $8.4 million, we identified and shared all this information with public staff, 30 substations in the mountain zone that were heavily impacted by Helene. We also looked in, was that work completed? Had we already done all that work? It was placed in service months ago, or maybe even last in 2023, or was it still open and in progress? Or maybe we hadn't even started it yet from that perspective. If that's the case, it was incomplete or we hadn't started yet, those are the ones we actually went and looked at. And to meet the timing of public staff filing their direct testimony, we agreed to look at 6 of those substations, did a physical walk down with our engineers and project managers, identified very specifically, they had the work orders that were engineered of here's the multi-year rate plan work that needs to be done on Smith Lane or wherever it was. And they actually identified what was done by restoration crews. Those blue sky costs were then backed out. the 8.4 million is an extrapolation of those 6 substations we walked down across the entire 30 population. We assumed that we'd see that same kind of overlap across the remaining 24 stations. So that 8.4 million represents what we believe to be the overlap for all 30 of those stations.
Okay. Let me just follow up and get to where I'm going now. I think you alluded to it a little bit. I read that E from Ms. Jiggett's testimony. And then Mr. Jurack talked about and reemphasized separate securitization with the bond for storm recovery from the rate base. Ms. Bateman said, agreed with me that it was separate. Tell me how in the world you're going to not allow some of the damage from Helene expenses that would not bleed over into the multi-year rate plan and in the rate base. How are you going to keep that differentiated and separate? I mean, the 3 poles you talked about already been done. The substations that were underwater, back online, but we needed to fix this or that. I mean, that seems like a massive undertaking to be able to separate both of them. Give me assurance and the commission assurance that what I asked about earlier is in fact going to happen.
So, and maybe I didn't do a real good job explaining it. So because we know exactly what work is identified down to the individual pole that would be replaced for our multi-year rate plans. And that is what is in rates. And that's already in or will become in base rates maybe in 2026. So we know what that work is. We also know exactly what work we had not done yet by the time we got there. Now, you mentioned substations. I had pictures in my direct testimony of the damage to build more sub, et cetera. Those are actually part of an insurance claim that we have. Poles and wires for distribution are not part of our insurance, but substations are. So you can set that part aside from that perspective. So really, we're talking the poles and wires outside of the substation. We will continue to do, while we only looked at 6 substations, we're going to go look at the other 24. That same process will happen where engineers and project managers will be boots on the ground looking at those particular projects. They know exactly what work is in their schedule to do. Was it already completed by Helene? And that work is ongoing right now. For that perspective.
Well, you use the word exactly 2 times there, so you must be exactly correct in the fact that you know exactly where all these expenses are going, right?
That's true, because what we have is in the securitization, it's all the collection of invoices and costs that we have from our estimates for the storm. What I know exactly is what work we were going to do as part of the multi-year rate plans. And if we see that work was completed with part of Helene restoration, that particular work will be removed from the securitization estimate because it will be or already is in base rates. So that's how we keep those separate.
Okay.
And Commissioner Tucker, may I add?
Yes, ma'am, go ahead.
So this is also a close partnership between our operations team and our finance team. As we were going through the evaluation of the 6 substations that Witness Guyton mentioned, is we were there with them, and we know now that those poles that were replaced in restoration will move with the accounting of the costs that go with them to the MYRP project. So we'll stay connected through all of 25 to make sure we keep those separate.
So, and those accounting methods that you use to keep them separate will be submitted in these bi-monthly meetings to public staff? So that they can verify that, or will they be able to verify, because it's such a massive project, between the 2?
So the bi-monthly meetings we have will be talking about the incremental O&M methodology.
Right.
The separation or the clarification of the MYRP project overlap would be trued up as our final costs are trued up in the next rate case proceeding.
With a full audit from public staff as well for all of that.
Yeah, I'm just thinking, how do you keep the O&M normal routine stuff from, that should go in the rate base, being charged to the securitization bonds and vice versa. I'm just, asking for my own edification there to make sure that they are, completely separate, and you both feel good about the fact that they will be separate and will be audited by public staff. Because I mean, I see in this settlement agreement, I see different numbers that came in after it came. I mean, I just can't imagine responsibility placed on Duke to be able to keep those separate and to be able to justify those to public staff, who in turn justifies those to us, so that we know that the rate base is truly the rate base for the MYRP, and then the other is what goes to charge to the bonds.
So we use unique project IDs for the work, not only
Okay.
with MYRP, but with the storm as well. So the MYRP work has work orders that the operations team use that are unique to those projects. We have a separate project ID for restoration work, but part of our process of finalizing cost is auditing those internally. And again, with this overlap that we've noticed, we will work closely with the operations team to clarify that. It will be provided in the reconciliation and true up and available for audit by the public staff.
Okay, and Mr. Guyton, you mentioned something, and I'll stop here with, you mentioned insurance, and you're part of an insurance claim on a particular part of it. And you may not be able to answer this question, but will there be a reduction in borrowing on bonds offset by the insurance the company already has? And do you plan to buy more for future storm damage, or how does that work, or do you know?
So I'll answer your insurance question, then I want to circle back and add one more thing to your previous question. So it's my understanding that because we were filing insurance claims for the substations that you saw and others as well, that was never included in our securitization ask, because we have a claim outstanding with our insurance. Is that correct?
That is correct.
One last thing I'll say is you're exactly correct that it is a daunting task, the speed at which we're trying to work through and verify what was done during restoration versus our projects. I would say the speed of doing that is probably more of the complication. Our projects that we engineer have very specific charging, work orders, et cetera. So what we're doing to validate during the storm is not different than what we do every day. It's just how fast we're trying to validate what those crossovers are from that perspective. And the same thing as we're preparing for a storm, and I talked about this in my testimony, the pre-storm activities, finance is one of the key functions in the incident management team. They're providing storm accounting, BIOP center, and other classifications that all the crews have before we ever start storm restoration. We use that throughout. And then of course, there's the audit process, but all it's not real different, except we need to move with speed and urgency.
Yeah, my whole point is so that the recovery fee that shows up on the ratepayer's bill that I couldn't get Ms. Bateman to agree to is no more than $2.
I can't speak to the $2, but that is absolutely our effort of if we're.
I'm done. Thank you, sir.
Okay.
Thank you, Madam Chair.
Yeah, and I just have one follow-up question, Ms. Jiggets, related to the questions I asked you about settlement exhibit 1 and the costs for Hurricane Helene.
Yes.
So the bonds are projected to be issued in October 25 is that's my understanding, correct?
Correct.
Okay. And so I think what we're really trying to get at is why are the costs going to be increased between October 2025, when the bonds are going to be issued, and the end of 2025, December 31st of 2025. So I may not have asked my question as clear as I should have, but why will we have additional costs between that after the bonds are issued?
We are trying to capture the incremental rebuild costs that we know we're going to have through the end of 2025. So there is some amount of spending that we know that is going to be associated with Helene rebuild and restoration that's going to happen after that securitization date. But because it's related to the storm, we're trying to pull that into the amounts that we're seeking through securitization to give the customers the benefit of the lower rate financing associated with that.
Okay. Thank you.
You're welcome.
Commissioner Levitas.
Just one clarifying question regarding incremental O&M costs. So as I understand it, the companies and the public staff had a disagreement about methodology. And in particular, the companies proposed the introduction of the so-called Florida rule, which I gather the public staff did not agree with. What I'm trying to understand is what was the size or the delta of the sort of difference in securitization costs reflected in that disagreement, and how was that settled? And I see a $100,000 reduction relating to incremental storm costs, but I'm not sure if that reflects a compromise in that disagreement around methodology or whether that was resolved in some other fashion.
So I'll just answer the $100,000 that you see reflected in the settlement is not related to the incremental methodology definition. That's
Okay.
separate. That's related to the issue that I talked through with Commissioner Cameron with respect to there were some costs that we identified that we adjusted the costs that make up that normal range of fluctuations. So it pulls
Right,
the
right,
costs
right.
out for Zeta.
So in the incremental O&M methodologies, the company did propose the Florida rule. Public staff mentioned in their rebuttal, why not look at our test year? So that's why in my rebuttal, you'll see mention of the Carolinas test year methodology. And in that methodology, there was about $2.5 million difference between the two.
Mhm.
But this incremental O&M can get very detailed. We focus on major cost categories such as labor and contract labor, from different sources, our material costs, but there's complexity in each of those when you start peeling back, and it's a rigorous analysis, very detailed. So the parties agreed we needed a little more time, and we plan to work together over the coming months and be ready in the next rate case proceeding.
Right. Thank you. So my question is just how was that $2.5 million difference resolved in the settlement? Did that stay in, come out?
So we agreed to the amount of total securitization that included the Florida methodology at this point.
Okay, so for the purpose of the settlement, the public staff accepted your number?
Public staff accepted the total securitization amount, which included that
Thank you.
methodology.
Okay, that comes to the end of commission questions. Are there any questions on commission questions?
Chair Cameron, I have one just for Ms. Culbreth. So Chair Cameron inquired about the estimation process for the 60 million reduction that's reflected in the settlement. Can you just provide an overview of how the companies get from the estimated cost to actual cost? What does that process entail, and what is the typical timeline for that process?
Sure. Our estimation, can I clarify one question? Do you want me to start at the beginning of the estimation process or once we have an estimate and getting to actions?
Yeah, just the cradle to grave process.
Oh, okay. So our estimation process, as I think I mentioned earlier, starts at the outset of the storm. And so finance is a major function included in the ERP that Brent Guyton has talked about. And we start there engaging with our planning team and our logistics team to understand some of the major costs. And those are our labor costs based on number of resources being utilized, both line and veg clearing resources, and our staging and logistics costs. At that point, we have assumptions in our model that add on, I guess, for materials, fleet, and the like. This is the initial stages. We have an internally developed model that we've been using for about 10 years. And then with all those inputs as they come in, we start our estimate, we update daily based on changes in those resources, based on the estimated time of restoration and other facts. After the storm restoration is complete, it takes our finance team about 7 to 10 days to finalize that estimate. Again, it's the initial estimate. Then we shift into monitoring and tracking those actuals. So each month, as internal costs are recorded, as we receive invoices from our vendors, able to process those, we are looking at our actuals compared to our estimate, as well as re-engaging with operations to clarify some of our assumptions, clarify our materials cost, true up with our vendors. We also go through a rigorous review of our vendor invoices that involves checking timesheets, validating against contracts to make sure the proper rates were used, all in trying to ensure costs from our vendors are accurate. In addition to that, my team spends a great deal of time verifying the transaction details that are captured in our financial systems, looking for mischarging. There is that chance, but we are doing thorough reviews every month to correct those. through the process and then month by month, comparing all of those actuals to that estimate and truing it up as we go. Those will get finalized in approximately 9 to 12 months.
Thank you, Ms. Colbreth. I don't have any additional questions.
Thank you all. Receive motions.
Chair Cameron, I would move that Mr. Guyton's direct and rebuttal testimony and summaries thereof be moved into evidence. I also move that Ms. Colbreth's direct and rebuttal testimony, the summaries thereof, and exhibits be moved into evidence. And I further move that Ms. Jiggett's direct rebuttal testimony and summaries thereof and exhibits be moved into evidence. And finally, I move that this panel settlement testimony and exhibits be moved into evidence.
Okay, seeing no objection, your motion is allowed. And for clarification, the 4 exhibits attached to Jiggett's direct testimony, 3 exhibits attached to Jiggett's rebuttal testimony, and the exhibits attached to the joint settlement testimony will be received into the record.
Thank you, Chair.
Thank you. Thank you very much for your testimony. You may step down and be excused. So my understanding is that there's a request to go out of order. Ms. Kress has asked that she be permitted to make motions at this time, and if there is no objection from the parties, I will allow her to do so.
Thank you, Chair Kimmerite. At this time, SIGFR would request that the 13 pages of pre-filed direct testimony that it caused to be filed in these dockets on behalf of its witness, Brian C. Collins, be copied into the record as if given orally from the stand, including one appendix consisting of 3 pages at the appropriate time so as to not mess up the order of the transcripts.
Okay. Seeing no objection, Ms. Kress, the direct testimony of Brian C. Collins consisting of 13 pages and 1 exhibit consisting of 3 pages filed on January 17th of 2025 shall be copied into the record as if given orally from the stand at the appropriate time.
Thank you very much.
Thank you. And if you need to leave, you may be excused.
Thank you.
Okay. Before we call the next witness, I think that it's time for our morning break. So we're going to take a 10-minute break. We'll go off the record and come back in at 2:57. Thank you.
Chair, at this time, the company's called Mr. Tom Heath.
Good afternoon, Mr. Heath. If you can place your left hand on the Bible and raise your right hand, and do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Chair. Good afternoon, Mr. Heath. Would you please state your name and business address for the record, please?
Yes, my name is Thomas J. Heath Jr. and my business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as a corporate finance director.
Mr. Heath, did you cause to be pre-filed in these dockets on December 2nd, 2024, 13 pages of direct testimony in question and answer form?
Yes, I did.
Do you have any changes or corrections to your direct testimony?
No, I do not.
Mr. Heath, if I were to ask you the same questions that appear in your direct testimony today, would your answers be the same?
Yes, they would.
And did you also prepare and file a summary of your direct testimony?
Yes, I did.
Turning to your rebuttal, did you cause to be pre-filed in these dockets on January 29th, 2025, 13 pages of rebuttal testimony in question and answer form?
Yes, I did.
And do you have any changes or corrections to your rebuttal testimony?
No, I do not.
And if I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
Yes, they would.
Mr. Heath, did you also prepare and file a summary of your rebuttal testimony?
Yes, I did.
Chair Kemmerite, at this time, I move that the pre-filed direct and rebuttal testimony, as well as the direct and rebuttal testimony summaries of Mr. Heath, be copied into the record as if given orally from the stand.
And as clarification, is the direct testimony, does it contain confidential provisions?
Thank you. Thank you, Chair. Yes, it does. There is a confidential provision in his direct testimony.
Okay, thank you. Just for
thank you.
clarification. So seeing no objection, the direct testimony of witness Heath, consisting of 13 pages and filed on December 2nd of 2024, that contains confidential provisions, will be copied into the record as if given orally from the stand. Also, Mr. Heath's rebuttal testimony, consisting of 13 pages, filed on January 29, 2025, will be entered into the record as if given orally from the stand. And also the summaries of his direct testimony and rebuttal testimony will be copied into the record as if given orally from the stand.
Thank you, Chair. Mr. Heath, did you have an opportunity to review the amended agreement and stipulation of settlement filed on December 12th, 2025 in this proceeding?
Yes, I did.
And do you support the amended stipulation as filed?
Yes, I do.
Chair, it is also my understanding that the parties have no cross-examination as a result of that stipulation. Therefore, the witness is now available for commission questions.
Okay.
Thank you.
Mr. Heath, this may be pretty quick because I think I'm the only one that has a question. The question that I have relates to rating agencies in regard to securitization. And correct me if my understanding is not correct, but my understanding is that the rating agencies consider securitization charges as a percentage of customer bills. Do they consider those charges as part of customer bills?
Yes, they do.
Okay. And can you provide a little bit more explanation about what exactly that means so that we can have a full understanding of that?
Sure. So one of the things that the rating agencies look at, we go to them to get a rating, we request a AAA rating on securitization bonds, is the level of all securitization charges, including the transaction that we're asking them about, as well as any prior transactions that are still outstanding. And they look at the level of that charge as a component of total customer bills, specifically residential customer bills. And they want to make sure that that securitization component is not too large in relation to the total customer bill.
And does Duke have any concerns that the securitization component that's going to be part of the customer bills, is that going to create problems or stress the ratings that Duke currently has from the rating agencies? Is there concern about that the ratings could be lessened or worsened because of the securitization?
Will the securitization charges affect Duke Energy Carolinas and Duke Energy Progress's credit ratings, not the credit ratings on the bonds? Or is it both questions?
Both.
Sure, okay.
Provide an explanation so that we can make sure that we have a full understanding.
So we would not expect those, the level of the charges we're talking about here. And we've not fully gone through that analysis yet. We've got revisions to make to our securitization models based on the settlement agreement. But once we run those through and determine revenue requirements or determine the charges by the customer class level, we will add that expected impact to the existing securitization charges, and we'll look at that as a component of customer bills, specifically residential customer bills. The charges on the existing bonds that are outstanding are less than 1% for Duke Energy Carolinas as customers today. And it's, I think, about 2 to 2.5% for Duke Energy Progress as customers today. Looking at just the relative value of the debt that was issued in 2021 compared to the debt we're looking at issuing in 2025, I would expect, and that haven't run the full numbers, but I would expect that we're looking at a 2 to maybe 2.5% adder for these bonds to that existing charge. So probably less than 5% in aggregate for DEP, and maybe it's 3% for DEC. So that's well below what the levels that the rating agencies get concerned about. That what they get concerned about is in the 15 to 20% range. Okay. So we're looking at charges that are going to be well below that. So that should not impact the ratings on the securitization bonds. We will request and expect to get AAA ratings on these bonds that we want to issue by the end of 2025. Those securitization charges, although they look at them from a component of the customer bills, the securitization debt and the related charges are excluded from the companies, meaning DEC and DEP's credit metrics. So there will not be any negative impact to the DEC and DEP credit metrics from the issuance of these bonds.
So just to be very clear, you're not expecting any negative impact at this point?
No, I would expect that these are going to be, the issuance of these bonds will be viewed favorably by the rating agencies because it will allow our credit metrics, which are in my testimony, I show the impact of these storms on our credit metrics. It will allow those credit metrics to return to their pre-storm impact levels.
Okay, thank you very much. Let me check to see if there's any additional questions. Commissioner McKissick.
Just a couple of questions. Good to see you again, Mr. Heath.
Very good to see you too, Commissioner.
Absolutely. Now, I know it's projected right now that October 25 is when the bonds are likely to be sold. What factors do you see as influencing a potential sale of the bonds earlier or delay in selling the bonds later based upon information that's available to you today?
Okay. So I will say that October date. So in our numbers, we've calculated carrying charges through the end of October. So in my mind, that means that we would expect to issue bonds either in late October to early November. Okay. We will have to look at market conditions and assess whether it's an appropriate time when we get to that point, assuming we go through the entire post-financing order process, right? The registration of the bonds with the SEC, the rating agency process, we go through marketing efforts. Once we're completed all those steps, we're going to have to assess whether or not that's an appropriate time to enter into the market, right? With the calendar that we've put together, that's included in our petition, our joint petition for financing orders. We show that calendar that's kind of targets that end of October, early November timeframe. But there are all sorts of things that can happen in the financial markets between now and then that may lead us to think that it's not constructive, right? If interest rates become very unstable or if they increase dramatically at a level where maybe they've increased so much where it deteriorates that customer savings calculation, right? The interest rate on the bonds is probably the most significant component of the customer savings, the quantifiable benefits calculation, right? So we'll be looking at all those things throughout the process. The efficiency with which we operate as a bond advisory team. So in our petition for financing orders, we've laid out a bond advisory team construct very similar to what we had in the 2021 issuance that you're very familiar with.
Very
A lot
familiar.
of calls together, right? So if, how efficiently can we run that bond advisory team process, right? And we believe there are efficiencies to be had over what we had in 2021 that gives us a fair amount of confidence to that late October, early November timeline, right? But how much debate goes on in that bond advisory team process can expedite things. It could also slow things down.
And as I recall, back in 2021, it's about $1 billion of bonds. It looks like we're looking at about $1 billion this time as well.
Correct.
But it seems like every week of delay was equivalent to about adding an additional 1.3 million to the cost or something to that extent. And I guess that's why I'm looking at this timing. I've been following what the Securities Exchange Commission has been doing in terms of the treatment of these, what I refer to generically as storm recovery bonds.
Right.
And their treatment in terms of whether they're treated as corporate bonds or corporate debt or as asset-backed securities.
Correct.
In the calculations that you have done at this point in time, what is it that you are anticipating they will be treated as? Corporate bonds, which you'll have a lower interest rate versus an asset-backed security, which could have a substantially higher interest rate, because that does ultimately tie back into the quantitative benefits to consumers or those that are ratepayers. So what are your thoughts? What are you seeing? How are you viewing it? And likewise, how that impacts registration, because that also has the impact on registration.
So there are two developments that have happened since 2021. One is what you just mentioned, the developments at the Securities and Exchange Commission over the last several months, where they have put out some compliance and disclosure initiative document, I believe it's called, that says that they believe that these are asset-backed securities and they should be registered as such. And there should be no disclosures in the registration statement saying that these are not asset-backed securities. Right? Those rules were not in place in 2021. The other development is, I'm trying to think of how long ago it was. So you remember we had this discussion about bond index eligibility in the Bloomberg Barclays bond indices back in 2021.
That's exactly right.
And at that time, we were able to choose which index we wanted to place these bonds in at Bloomberg, corporate index or ABS. We chose the corporate index. Others had chose the ABS index. And so there was a disparity in treatment between bonds that looked very similar. Bloomberg conducted a survey, I think is probably the right word to use, from market participants, including issuers of utility securitization debt, and asked how we thought those bonds should be treated. We responded to that survey. We made our case for these should be put into the corporate bond index. Bloomberg subsequently, after that survey, made their determination, and their conclusion was that these would going forward be put into the ABS index, asset-backed security index, and no longer be considered for the corporate bond index. So those are developments that have happened since 2021. I would say that even within the context of those developments, we will take these bonds to market no different other than following those parameters, right? Bloomberg says this is how they're going to be treated. The index are going to go in. The SEC says don't make these kind of disclosures, and we won't make those. We don't intend to make those kind of disclosures. Other than that, we're going to approach marketing these bonds, structuring, marketing, and pricing these bonds very similar to what we did in 2021. And the biggest factor to successful pricing of these bonds and deriving customer benefits, customer savings, is to reach out to the broadest spectrum of investors that we can talk to. And so we would use the term, we want to take an investor as not agnostic approach. I'm going to go out and talk to investors. I don't care if they normally buy ABS, if they normally buy corporate. I want to talk to the broadest spectrum of investors and get as much interest and demand into this offering as possible, so that we're trying to sell $1 billion. I want to have orders of $3, $4, $5 billion, because when we have that kind of order book, we can tighten in pricing and get to a lower interest rate. If we were trying to sell $1 billion and all I have is interest for 1.2 billion, it's a little harder to do that. So we'll approach that structuring, marketing, and pricing process no differently, other than those couple exceptions that we have to follow Bloomberg guidance, and we're not going to make that. We won't be able to make that disclosure that we're not an asset-backed issuer. Everything else will look much like what we did in 2021.
Yeah, I was aware of what Bloomberg had made in terms of a determination, which seemed to have precipitated the Securities and Exchange Commission reevaluating their treatment as corporate bonds. So, I mean, I guess that also means that ultimately, while we can try to market these bonds to a wider audience, there will be certain institutional investors that may not purchase because they're not corporate bonds. Is that a?
I mean, I hear that said in different venues. But from our experience in all of the transactions that we did, in going back to 2016 in our Florida transaction, the 2 transactions we did in 2021 from in North Carolina, and then the transaction we did in April of last year, almost a year ago now, in South Carolina, I never got that kind of feedback that I'm passing on this because it doesn't look like this, right? We presented this based on the strength of the credit, and that this is the rating agencies have done their analytical work and their robust stress scenarios, and they conclude that this is still ABS. We talk about the sponsors being that these are high quality utilities, very strong utilities. I would say premier utilities in the US, particularly in the Southeast. And then that the service territory here is robust, right? We've got over 2.5 million customers that are paying these charges. We've got significant economic growth coming into our service territories. All those things are looked upon favorably, not only by the rating agencies, but also by investors. And that's what's really going to drive interest in the transaction versus is this in this index or this in the other. It can be important to some investors, but like I said, our experience is that we have not had anyone communicate to us throughout 4 transactions, right? I look at the North Carolina ones as 2 separate transactions. We've not gotten feedback that we're passing on this deal because, you know, Bloomberg is putting it in this index.
So I take it that in your projections as terms of the cost of transactions and what the yield might be on these bonds, or pricing, I should say, it's a better term, or you're factoring in a higher interest rate now, since they're going to be treated as asset-backed securities as opposed to corporate bonds. I mean, are you factoring in an additional 1%, 1.25%, or how have you approached your projections?
What we would look at is first thing is other utility securitizations that have priced recently, and there's been a fair amount of activity, not as much as there was in 2021, and over the course of the 9 months or so before we priced our deals in November of 2021. There's still been a fair amount of activity there. So there's good market comps out there in this particular space, and we can see how those have priced. We're also going to look at as another measure, we will look at other AAA rated ABS products, particularly as comparable securities for the shorter duration bonds. So we're going to slice this $1 billion up into multiple tranches. Some of those are going to be of shorter duration, meaning they're going to repay within 2 to 3 years, and others are going to be a longer duration, meaning they're going to repay in 10 to 15 years. And so those shorter tenors are going to be more interest to ABS type investors. So we're going to look at relative value of our transaction compared to high quality, the highest quality things in the ABS space. And then on the longer duration, we're going to look at AAA corporate bonds. How do these look in terms of comparison to things like a Microsoft or an Apple that are AAA rated? There's very few AAA rated corporates out there, but we'll look at those that are available. And then we're also going to look at these in comparison to our first mortgage bonds that we issue at the utilities. We're going to take all those things in context.
Excellent. I appreciate your testimony. I was curious as to how you were analyzing it in light of the changes that have occurred since 2021. So I appreciate your testimony, and we'll see how this all moves forward, particularly with the new bond advisory team. And
Yep.
I think the information you provided related to a reevaluation of the tranches could be insightful. Thank you.
So we'll move on to see if there's any questions on commission questions. Mr. Creech.
Just have one quick question. Mr. Heath, good to see you again.
Very good to see you.
And I think today we may have delved in a little bit into the second phase of this proceeding. Are you aware that the public staff will be engaging a consultant to work with the public staff to interface with the company and the parties on this?
I have heard that, yes.
Okay. And one of the things we might discuss in that context is whether these will be ABS or corporate bonds, et cetera, or is that correct?
I think the determination at Bloomberg has been made, right? And they're saying these are ABS. These will go into their ABS indices. And then the development at the Securities and Exchange Commission is that they put out some staff pronouncements that say to not make these type of disclosures about these not being asset-backed securities. So I would say that our position going in is that we follow the guidance that are out there from those two entities. We certainly can have some discussions within the bond advisory team's construct about what that means. How does that impact these transactions? And is there anything that we can do to present these as, as a better comparison, a better security than other utility securitization bonds that have been issued by other utilities.
And just one final question, because I know probably move on, but are you aware that, for example, various governors in NSUCA, there's a NSUCA resolution out there on this very issue?
Yeah, I'm aware of the governor's letter. Yes.
Okay. All right. Very good. No more questions.
Before we move on to see if there's any additional questions on commission questions, we do have one, or at least Commissioner Tucker has at least one more question.
Mr. E, thank you for being here. Tell me how much debt Duke is managing now, Duke Energy, encompassing the whole corporation?
The whole of Duke Energy, I believe it is somewhere in the area of $70 billion.
Okay, thanks, sir.
Okay, so we'll go back to questions on commission questions and including the question from Commissioner Tucker. Any additional questions, Mr. Creech? Okay. From Duke?
Chair, just one question, following up on Commissioner McKissick's question, as well as Mr. Creech's question. Just for the record, Mr. Heath, will you be back to speak through and talk about in more detail, the discussion that was had here today, in addition to related topics as part of the next phase of the securitization proceeding?
Yes, I will.
All right, thank you. No further questions.
Mr. Heath, thank you for your testimony. You may step down and be excused.
Thank you.
So I will entertain any additional motions from Duke if there are any.
Yes, thank you, Chair. Chair, at this time, I ask that Mr. Heath's direct and rebuttal testimonies, as well as his direct and rebuttal testimony summaries, be moved into evidence.
Okay. Seeing no objection, your motion is allowed.
Thank you.
Okay. Is there anything in addition from Duke?
Nothing additional.
Okay. Thank you. So we will move to the public staff now.
Yes, Chair Cameron, thank you. The public staff now calls witnesses Boswell, Brown, Cofield, Maida, and Zong to the stand.
Okay, so I'll go ahead and get you sworn in. If you can place your left hands on the Bible and raise your right hands. And do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Okay, to proceed. Chair Cameron.
Yes, please.
Okay. Good afternoon. Ms. Boswell, would you please state your name, business address, and current position for the record?
Michelle Boswell, Director of Accounting for the Public Staff. My business address is 430 North Salisbury Street, Raleigh, North Carolina.
Mr. Brown, would you please state your name, business address, and current position?
Yes, my name is Darrell Brown. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst for the Accounting Division of the Public Staff. You may repeat that. Darrell Brown, my business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst for the Accounting Division of the Public Staff.
And Mr. Cofield, would you please state your name, business address, current position for the record?
Sure. My name is Darius Cofield. My business address is 430 North Salisbury Street, Raleigh, North Carolina. And I'm a regulatory public utility analyst for the Accounting Division of the Public Staff.
Mr. Maida, would you please state your name, business address, and current position for the record?
My name is Hemant Mehta. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst with the Accounting Division of the Public Staff.
And finally, Ms. Zong, would you please state your name, business address, and current position for the record?
Yes, my name is Fan Zhang. My business address is 430 North Salisbury Street, Raleigh, North Carolina. My current position is public utility regulatory supervisor of the Public Staff Accounting Division.
Thank you so much. Now, Mr. Cofield, on January 17th, 2025, did you and witnesses Brown, Maida, and Zong prepare and cause to be pre-filed joint direct testimony in this docket, in these dockets consisting of 44 pages, 4 appendices, and 3 exhibits?
Yes.
Do you have any corrections to that pre-filed direct testimony?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
Mr. Cofield, on February 11th, 2025, did you and witnesses Boswell, Brown, Maida, and Zong prepare and cause to be pre-filed joint settlement testimony consisting of 7 pages, 1 appendix, and no exhibits?
Yes, that's correct.
And was that same testimony filed again the next day on February 12th to additionally reference the financing order proceeding dockets, both in the caption and the footer? And those dockets are, is a combined 4 dockets, which are E7 sub 1321, E2 sub 1362, E7 sub 1325, and E2 sub 1370.
Yes.
Okay. And if you were asked the same questions today, would your answers be the same in that? Well, excuse me, do you have any corrections to that joint settlement testimony?
No.
And if you were asked the same questions today, would your answers be the same?
Yes.
Okay. And lastly, did you and witnesses Brown, Maida, and Zong also prepare and cause to be pre-filed on February 11th, 2025, a summary of your joint direct testimony and dockets number E2 sub 1362 and E7 sub 1321A, excuse me, E2 sub 1362A and E7 sub 1321A?
Yes.
And did you and witnesses Boswell, Brown, Maida, and Zong prepare and cause to be pre-filed on February 12th, 2025, a summary of your joint settlement testimony and docket numbers E2 sub 1362A and E7 sub 1321A?
Yes, that's correct.
Chair Cameron, at this time, I move the pre-filed joint direct testimony and the pre-filed summary of direct testimony of public staff witnesses Brown, Cofield, Maida, and Zong, and also move the pre-filed joint settlement testimony and summary of joint testimony of public staff witnesses Boswell, Brown, Cofield, Maida, and Zong be entered into the record as if given orally from the stand, that the public staff direct joint testimony exhibits 1, 2, and 3 be marked for identification as pre-filed.
Okay. Seeing no objection, the public staff's joint direct testimony consisting of 44 pages with appendices A through D filed on January 17, 2025, along with a summary of the joint direct testimony And in addition, the joint settlement testimony of the public staff consisting of 7 pages and Appendix A filed on February 11, 2025, and again on February 12, 2025, along with the summary of the joint settlement testimony be entered into the record as if given orally from the stand.
Thank you. Mr. Cofield, do you have a summary of the joint settlement testimony that you would like to read?
Mr. Creech, did you, let's go ahead and mark for identification purposes. I may have forgotten to state that. The 3 exhibits that are attached to the public staff's joint direct testimony will be marked for identification purposes as pre-marked.
Thank you so much.
Okay, thank you.
Mr. Cofield, do you have a summary of the joint settlement testimony that you would like to read?
Sure.
Thank you.
The purpose of our joint settlement testimony is to support the agreement and stipulation on prudency review proceeding and assumptions to be used in cost-benefit analysis and financing orders proceeding stipulation filed on February 11, 2025. Entered in between Duke Energy Carolinas LLC, DEC, Duke Energy Progress LLC, DEP, and the public staff stipulating parties as it relates to the prudency review of the storm costs included in the securitization filing by DEC and DEP, and this proceeding as it relates to assumptions to be used in quantifiable benefit analysis in the next phase of the securitization proceeding. The stipulation set forth the agreement between the stipulating parties resolving all issues regarding the calculation and prudency of the storm costs for Hurricanes Zeta, N, Debbie, and Helene, and Winter Storm Izzy for DEC and DEP. In this proceeding, as well as settles the assumptions to be used in the quantifiable benefit analysis in the next phase of this proceeding. As detailed in this testimony from the perspective of the public staff, the most important benefits provided by the stipulation are as follows. An aggregate reduction in the company's proposed storm costs for securitization in the proceeding, resulting from adjustments agreed to by the stipulating parties, and the avoidance of protracted litigation between the stipulating parties before the commission and possibly the appellate courts on the settled issues. Based on these ratepayer benefits as well as other provisions of the stipulation, the public staff believes the stipulation is in the public's interest and should be approved. Thank you.
Chair Camerite, the panel is available for commission questions. It's my understanding there are there's no cross.
So
I'll proceed with a few questions. Most of the questions that we have already been answered by Duke witnesses, and I'm not going to repeat those questions. I'd like to start with Ms. Boswell. This may be for you or whoever would like to answer the question. Help us to understand the investigation that the public staff did for this application. We did hear from Duke's witnesses that the public staff not only reviewed filings and participated in discovery, data requests, but also went to Western North Carolina and had in-person, viewed the storm damage in person. So can you just provide a little bit more information about how your investigation was handled?
Yes, the public staff did send members of its engineering team to the mountains, both to view the water and sewer systems that were affected by Hurricane Helene, as well as the electric systems that were affected by Hurricane Helene, when it was safe to do so and when it would be non-cumbersome for those who had been affected by the storm for us to be there. In addition to that, upon the company's filing of its securitization filing in this proceeding, we undertook an audit of the historic storms for Zeta, Izzy, and Ian, as well as looking at the estimated costs related to Helene and Debbie.
Okay. So Ms. Boswell, is it fair to say that the public staff performed a complete and thorough investigation and audit of this application?
There is still the pending audit for the actual storm cost for Helene and Debbie, which will take place in the company's next general rate cases.
That's correct. And there was some discussion that we asked Duke the witnesses some questions about the settlement. And I'm going to ask the same questions that I asked of Duke witnesses about public staff's position. You have entered into this settlement. There was give and take concessions, give and take in order to reach the settlement. What is the public staff's position? You are asking that the commission approve the settlement. Do you believe that it is in the public interest and something that the public staff fully supports?
The public staff fully supports the settlement issue that the companies company Sigfer, Kuka, and the public staff entered into in this proceeding and recommends approval of such.
And was there give and take of different provisions that resulted in the settlement from public staff and Duke? Can you talk a little bit about, there were concessions made by all parties. Is that correct? And if so, provide a little bit more information so we can have it on the record.
Yes, ma'am, and I will let my counterparties behind me speak to all of the concessions that we feel were made.
Okay. And I think that probably the high-level concessions might be more appropriate. I'm sure that there were many minor adjustments, but if you could just give an overview of the most important concessions that the public staff has made.
Absolutely.
Yeah, the company, good afternoon, commissioners, and the company for the DEC has asked for $845 million, and for the DEC, it's asked for $591 million, a total of $1,436 million. After the settlement we have reached is $1,045 million. And as part of this one is $391 is the reduction from the application. The $300 million is for the storm reserve between the DEP and the DEC, and about $10 million as a result of the audit of our costs. And then there was some overlap between the MYRP projects. That was the second one. The third one is about $21.3 million reduction as a result of carrying cost calculation to reflect debt only instead of the weighted average cost of capital. And the third thing is $60.3 million as a result of change in the estimates for storms Debbie and Helene made by the company. Those were the big major ones.
Okay, thank you. Is there anything else that anyone wants to add to that? But that is a good overview.
That's it. That's a good overview, but there are in details in there if you want me to go in.
I don't think we need to go into the details. I want to give the public staff an opportunity. We asked a number of pretty technical questions of Duke witnesses. I don't want to go through all of those questions, but if there is anything that was answered by Duke that the public staff objects to or disagrees with or wants to add to, I want to give the public staff an opportunity to put it on the record.
Chair, I would say we did not object to like disagree, but we still have some couple issue that we believe we will address either in the other case or the next general rate case. So as you probably know that one of them is the incremental O&M methodology. We are going to discuss bi-monthly to get a resolution hopefully before the next rate case. But if not, we will still present our position on that for the commission to decide.
Okay. Thank you.
Yeah, and then the other piece, it will be the weighted average cost of capital, the use of it in the carrying cost calculation. So we still have a fundamental disagreement on that. So we will adjust in the other cases.
Anything else that the public staff would like to add based upon the questions that we asked to Duke? I think it was, we received thorough answers, but Ms. Boswell, is there anything else that needs to be addressed?
First, the public staff would like to commend Duke on its efforts in restoring power through all of the storms that were part of the securitization filing. It was quite the undertaking, and they should be commended for restoring power so quickly back. The public staff, this was a contentious, as per the testimonies filed before the settlement would have shown, this had contentious issues associated with it. Appreciating that the company thought that we were being petty and improper in some of the adjustments we made. The public staff in everything that is filed before this commission vigorously vets all filings and makes recommendations based off of commission precedent and what we feel is both equitable and fair to both the companies and the ratepayers. That aside, we fully support the settlement that's before the commission today.
Okay. Well, we appreciate the work of all of the parties in investigating the application and coming and entering into the settlement. So let me check to see if there's any questions from the other commissioners. Commissioner Brawley.
Thank you. Ms. Boswell, there's great deal of discussion of the give and take, and we saw a lot of things that were negotiated back and forth. But there was a question I asked about earlier, and that was on the something that was, if I may direct you to your settlement testimony on page 4, reduction of the carrying cost to reflect debt only return on Hurricane Zeta and Ian and Winter Storm Izzy. And in other places, including the stipulation, it lists the same thing, but makes a comment instead of the weighted average cost of capital authorized under North Carolina General Statute 62-172. It was a $16 million difference, and that $16 million difference arose of the operation of the laws passed by the General Assembly. While y'all were negotiating and doing give and take on issues where there was disagreement, I was wondering why that number was even in disagreement, since it followed the general statutes.
While the general statute does allow for a return up to and including the weighted average cost of capital, the issues from the public staff's view outside of the settlement, which we fully support and agree to in this case, related to the timing associated with the length of time from when some of the storms occurred from when they were actually being sought for recovery.
Could you expand that so I might better understand what you mean?
Sure. So for instance, Hurricane Zeta was, I believe, a 2020 storm subject to check. The company filed for securitization in December of 2024. So that 4 years of carrying cost is what the public staff in its direct testimony took issue with. Was that really prudent and proper to be recovered?
Does the general statute put conditions on the terms in which the weighted average cost of capital can be collected?
It is my understanding, based off of the advice of legal counsel, as I am not an attorney, that there is disagreement between the companies and the public staffs over the interpretation of the storm securitization statute and the cost that it does and does not allow to be recovered.
So if I'm understanding correctly, public staff believes a straight reading of the text of the statute doesn't apply?
Again, it is based off the advice of my legal counsel that there has been differences of opinion between the company and the public staff over the interpretation of the storm securitization statute and all of the costs that can be recovered through there.
Okay. One thing I was wondering, if the general statutes allowed them to collect at weighted cost of capital, if there was another instance where something was in dispute, could you conceive of a circumstance where the public staff would support Duke being able to recover at a rate higher than authorized in the general statutes?
Every case is handled on a case-by-case basis, and I never say never to anything. I would say that in order for us to do something that would be above a commission-approved weighted average cost of capital, there would have to be such extraordinary circumstances that such would be warranted. And it would still, from my view, still have to be approved by the commission to have earned something above what the commission-approved weighted average cost of capital would have been.
Okay, I expected you just say no, because that's where I would be on it. And I think
I would have a tendency of leaning that way, but again, we handle everything on a case-by-case basis.
Well, the concern that I have, having been a legislator, is that the laws sometimes are fairly clear in what they say. And we've had situations, well, I'm just concerned where everybody says they are authorized the weighted average cost of capital under the general statutes. Doesn't say they're authorized that in some circumstances. And then in this one, it ended up being in dispute. Now, I concede they agreed to the lower amount, but I'm still curious and really trying to understand why it was even part of the negotiation.
Well, and again, it wasn't that the weighted average cost of capital was in dispute. It was whether or not the amount of time for which the return should have been earned was in dispute.
Would it be fair to say you're just saying they waited too long to file for it? And if they tried to securitize that 16 million separately 4 years ago, we wouldn't have had the dispute?
That is another way of saying it, yes.
Okay. Thank you.
Commissioner Tucker?
Just a quick question, whoever wants to answer it. You denied Duke's request for a $300 million storm recovery fund, reserve fund. Why is that? And then in the future, is there consideration, since you kind of nibble around the edges with the Florida rule and it's new, that you're wait and see as that developed? Because I think I read that you did not, the commission had never done that before in that manner. Therefore, you were not going to allow it at this time. Is that kind of correct? And
I'll take that one. The stipulating parties in the settlement agreed to remove the storm reserve for both companies. But they also agreed to partake in future in
Mr. Brown, I didn't hear that. I didn't hear that. In the future, they plan to do what?
We plan to partake with the company in good faith discussions. Good faith discussions to look at reserves, but we want to look at it from a holistic standpoint and look at all the tools that are available to the companies to recover storm costs. This includes storm normalization, storm securitization, and deferral, and take that into consideration and balance that in an equitable manner so that the companies and ratepayers are not taking on more risk than the other. So this is something that we plan to look at in the next rate case proceeding.
Okay. But that's fair, but you just, the money hasn't been spent, hadn't been utilized yet, and storm hadn't come yet, and you guys got a problem with that, right?
That's correct. I mean, you have to consider that you're looking at customers that are severely impacted by recent storms such as Helene, and there's recovery associated with that. And to now place another cost on those same customers that are impacted by these major storms for future storms is something that needs to be looked at carefully, closely in the future.
Okay, I got it. I thought that was it, but you're always looking out for the ratepayer, and that's your job. Thank you.
You're welcome.
Did you want the Florida rule piece? Because that was slightly different than the storm reserve as well. I know. Fair enough.
Okay. Commissioner Tucker, did you have another question?
I read the definitions. I mean, you're going to circle back on it, so I'm fine with that.
Okay. Okay, thank you. So we will move on to questions on commission questions.
No questions from Duke Energy.
Ms. Gray?
Just a couple quick ones, if I could, please. First, on Commissioner Brawley's questions related to Zeta, that the expenditures there, that was a 2020 storm. They're about $13 million there, and $5 million in carrying costs to take you to $18 million. Is that correct?
Subject to check, yes.
And so, just to put a point on the end, one of the points of contention, and it's in the testimony. There's definitely back and forth, but one of the main points of contention was it's an older storm, right? And how quick the company came in on that. Correct?
That is correct.
All right. Now back to the storm reserve question that Commissioner Tucker had. At this stage, there is not a storm reserve, and never has been to this date in North Carolina. Is that correct?
That is correct.
But the parties Duke and the public staff will be working in dialogue on kind of the whole gambit of storm normalization, storm reserve, those issues here going forward. Is that correct?
Yes, in the next rate case.
All right, and just to put a fine point on it, the question about storm victims being, well, folks who've been impacted by the storm, ratepayers, the storm reserve request in this would have been about 20% more ask on top, right? 300 million on top of the
300 million total, percentages subject to check.
Okay, okay. Just and final point, and this I think is for Ms. Boswell. We've talked a lot about the settlement today, but we're referring, the public staff supports the amended settlement. Is that correct?
That is correct.
Okay. No more questions at this time. Thank you.
Okay, thank you. So Mr. Creech, I will entertain motions from you.
Yes, please. Thank you. Chair Camerite, the public staff moves the 3 exhibits attached to the pre-filed joint direct testimony of witnesses Brown, Cofield, Maida, and Zong to be entered into the record and marked for identification as pre.
Okay, seeing no objection, the 3 exhibits that were attached to the joint public staff's joint direct testimony will be entered into the record. Okay, any additional motions or matters from any of the parties? Okay. Public staff, thank you for your testimony. You may step down and be excused. We will we'll have proposed orders being filed 30 days after the transcript has been prepared. And if there's no additional matters, the hearing is concluded and we'll go off the record. Thank you. Steve. Let's go back on the record. I need to make a clarification. The proposed orders are to be filed within 15 business days of today. Is that correct? Okay. 15 business days of today's date, proposed orders are to be filed. Okay. Thank you, and we will go off the record.